everybody. Please take a seat. Is there anything before we start?
Just to report to the court, it's not here. Highly unlikely, I think, that Dr. Proctor will arrive today. Both sides conferring with counsel once we get to the same place, has the same information. We provided a list of documents in defense, most of which are industry documents, any of which would be made in a statement. We would offer evidence and publish portions thereof if we have time for evidence this afternoon.
Okay.
And I think, Your Honor, we can take that up after Ms. Henninger finishes. We're going to have some argument about some of the documents. We also need to raise some concerns about just general scheduling issues, how long we have for trial, witness issues, and so forth. We didn't expect to be doing nothing this afternoon other than arguing documents. So these are things I guess we can take up when we're done with openings.
All right, let's go ahead. We'll bring the jury in. You can do your opening. We'll take a short break. After that, the documents that you all agree on, we can do those today with the jury. After you go through those, we can release them, and I can meet with you all regarding the ones that are objected to in scheduling.
I think Mr. Green is reviewing them right now, so we'll be able to save some time for the court.
Okay. All right, Victor, please bring everyone in. Push this over.
All right.
Welcome back, ladies and gentlemen of the jury. Please take a seat. Victor, please pass out your notepads. All right. Ms. Henninger, you may proceed.
Thank you. May it please the court. Counsel, Mr. Wilcox. Well, good afternoon, ladies and gentlemen. I find myself much like I did last week, where I get to talk to you after lunch, and everybody's tired and heard a lot of evidence, or what the evidence will be in this case, and I hope you bear with me for a little bit longer. I want to walk you through some evidence because, as you recall, last week when we were doing jury selection, we spent 4 days together talking about issues in this case, but what we weren't allowed to do was talk to you about any of the evidence. And that's what we're going to be doing today, is talking about what both sides believe the evidence in this case will show. And it will come as no dispute, because this is a trial, that there's a little bit of dispute as to what that evidence is. Both parties have their own view, and that's what the purpose of opening statements is. And you heard a lot in Mr. Gustafson's opening statement about tobacco companies in general. You heard a lot about RJR. You heard a lot about the Engel findings. And you heard some about Mr. Wilcox. And what's very important to remember is that this is Mr. Wilcox's case. This is a case about Mr. Wilcox, who was the smoker. And I'm going to refer to him as Mr. Wilcox. His name was Cleston Wilcox. Some people called him Red, as you heard Mr. Gustafson say. And it's a little bit confusing because we have another Mr. Wilcox here. Robert Wilcox is his son, is the plaintiff in this case. And you may hear from even another Mr. Wilcox because Mr. Wilcox, Robert, has a brother named Michael. But for the purposes of today, I'm going to call the smoker in this case Mr. Wilcox. And it's important to remember that this is his case for one very important reason. As you recall, when Judge Lindsay read you the instructions that you had before you heard any opening statements, she told you at the end of this case you're going to get what is called a verdict form. And a verdict form is a series of questions that you'll be asked to answer based on the evidence you've heard in this case. And I say it's important to remember that this is Mr. Wilcox's case. It's about the smoker, Mr. Wilcox, because every question on that verdict form will have his name on it. So when you're listening to the evidence in this case, you have to ask yourself, what does the evidence have to do with Mr. Wilcox? Because if it doesn't have anything to do with Mr. Wilcox, it's not going to be very helpful for you at the end of the case when you need to render your verdict. And I want to give you an example of what I mean by that, things that may or may not have to do with Mr. Wilcox. And Mr. Gustafson, in his opening statement, talked about something called a frank statement to cigarette smokers. You may remember that because he spent almost 5 or more minutes talking about the frank statement to cigarette smokers. He talked to you about how it ran in, I believe he said, 448 newspapers across the United States. That it was an ad, a full-page ad that was taken out in those 448 newspapers, and that newspapers back then were a big source of information for individuals, and they were. But what he didn't tell you is that Mr. Wilcox, as a Marine, he was a Marine, what he didn't tell you is that during that time, when the frank statement ran in 1954, of January 1954, Mr. Wilcox wasn't in the United States. He was in Japan. And he was in Japan from November of 1953 until December of 1955. There is no way he saw, heard, or read the frank statement. Because the simple fact of the matter is that none of the newspapers that the frank statement was published in made its way to Japan. And you're going to hear evidence in this case that the only newspaper that servicemen and women received overseas was something called the Stars and Stripes. And we're going to talk about what information was available in the Stars and Stripes for servicemen and women, and they talked about the dangers and addictiveness of smoking. So that's an example of when you hear evidence, ask yourself, is there a connection to Mr. Wilcox? Because that connection is what you're going to need to render your verdict in this case. Now, you heard a lot of that. Mr. Gustafson talked a lot about General Tobacco Company conduct. He talked a lot about the Engle findings. And this case is not about General Tobacco Company conduct or the Engle findings. You recall on jury selection, and the judges instructed you that the Engle case was a class action that's already been tried. And we are here to focus on the claims being made in this case about Mr. Wilcox. So, before we go much further, there was a lot said, and I want to talk about what this case is not about. I've told you it is about Mr. Wilcox, but what it's not about is banning cigarettes. Can everybody see if I'm standing here? Okay. This case is not about banning cigarettes. As you heard in Madeira, cigarettes are legal. This case won't change that. There's no banning of cigarettes in this case. It's not about whether cigarettes are dangerous, because they are. This case is not about whether cigarettes are addictive, because they are. And it's not about whether cigarettes cause cancer, because they can. It's not about the public health and welfare. It's not about the morality of marketing and selling cigarettes. It's not about smokers in general, because it's about Mr. Wilcox. It's not about any smoker other than Mr. Wilcox. Now, there are very specific issues that you're going to be asked to decide, and that's the verdict form you'll get at the end of the case, and we don't know what that looks like at this time. But this case is about Mr. Wilcox, and some of the issues that you're going to decide in this case are as follows. The first thing you're going to have to ask is whether or not Mr. Wilcox was a member of the Engle class. And as part of that, you're going to have to ask whether or answer.
That slide is argument. Doesn't accurately state.
Okay, can I see you all at sidebar, please? Thank you, counsels. Ms. Henniger, you may proceed.
Thank you, Your Honor. Whoops. Okay. So, I forget if I read any of these, so let me start from the beginning. These are some of the issues that you're going to decide in this case. And the first issue is whether or not Mr. Wilcox was a member of the Engle class. And as part of that, you're going to have to decide whether or not Mr. Wilcox died from a primary lung cancer caused by cigarette smoking. And the next issue you're going to be asked to decide is, was Mr. Wilcox addicted to cigarettes? And if so, was that addiction a legal cause of his lung cancer and death? And I want to read to you the instruction that Judge Lindsay gave you this morning about addiction causation or legal cause. And it's an addiction to smoking cigarettes containing nicotine is a legal cause of injury if it directly and in natural and continuous sequence produces or contributes substantially to producing such injury, so that it can be said that but for the addiction to cigarettes containing nicotine, the injury would not have occurred. In other words, plaintiffs will have to prove that but for Mr. Wilcox's addiction, if he was addicted, his lung cancer and death would not have occurred. Then the third question is, did Mr. Wilcox develop a smoking-related primary lung cancer and die because the dangers and addictiveness of cigarettes were unknown to him? And there's a concealment claim in this case. You heard Mr. Gustafson talk about it. And you're going to have to ask yourself whether he knew that smoking was dangerous and addictive, and the evidence will show you that he did. And finally, the question is Mr. Wilcox's estate entitled to money damages when the evidence will show that he chose to smoke despite knowing the risks? And we'll talk about all of these things a little bit further as we go down the evidence in this case. Now, I know that I talked about already, and I cleared the air about the Frank statement and told you, ask yourself what some of the evidence has to do with Mr. Wilcox. But there are some other things that Mr. Gustafson ended on today in his opening statement that I wanted to address with you. And these are the facts. And I was a little confused because some of this information, in fact, all of this information, comes from plaintiff's own expert. Potentially the first witness you will hear from in this case, Dr. Proctor, will tell you these things, that cigarettes are dangerous and addictive by nature. That's how the plant grows. Nicotine occurs naturally in tobacco. Again, tobacco companies didn't put nicotine in tobacco. It grows there. And importantly, one of the things that you're going to learn in this case is that there is less nicotine in cigarette tobacco than in natural tobacco. Well, that's kind of awkwardly worded, so let me explain that to you. What that means, if you were to go to northern Florida or Georgia or North Carolina, someplace where they still grow tobacco, and you pulled a piece of tobacco out of the ground and you dried it and you smoked it, not only would it have the same carcinogens, but remarkably, it has more nicotine in the plant that you pull from the ground than in the tobacco that is found in the cigarettes that you buy at the store. We heard a lot about designing for addiction, but the fact of the matter is that there is less nicotine in cigarette tobacco than in natural tobacco. Now, you will also hear that roll your own cigarettes. Again, if you take tobacco, you roll it up yourself, and you smoke it, roll your own cigarettes are just as dangerous and addictive as manufactured cigarettes. So the idea or the claim that cigarettes are made to be dangerous and addictive will not be supported by plaintiff's own experts in this case. And importantly, you heard a lot about additives, ammonia, and all sorts of things that were added to cigarettes to either increase addiction or do something else during Mr. Gustafson's opening statement. But the fact of the matter is, well, the additive-free cigarettes are not any safer, and they're not any more or less addictive. In other words, additives don't make cigarettes more dangerous or more addictive. The simple fact of the matter is that cigarettes cannot be made safe. There is not going to be a single witness that will come into court and tell you how to make a safe cigarette. And that's because it can't be done. There's no public health consensus as to this is how you can make it safer or this is the level of nicotine that should be in cigarettes. In fact, R.J. Reynolds has spent billions of dollars trying to make a safe cigarette, and it just can't be done. Cigarettes are dangerous and cannot be made safe. Now, you also heard Mr. Gustafson say that the tobacco companies created the inhalability of cigarettes in order to addict smokers. And somehow the idea was that R.J. Reynolds and other tobacco companies made cigarettes inhalable, and that they weren't inhalable until they started mass producing cigarettes in the United States. But the evidence is going to show that cigarettes have always been inhalable. Again, this will be coming from Dr. Proctor, plaintiff's first witness. Dr. Proctor will also tell you that roll-your-own cigarettes are inhalable, and cigarettes were inhalable before R.J. Reynolds ever manufactured a single solitary cigarette. Since the 1800s, it has been known that cigarettes are more dangerous than pipes and cigars because they're inhaled. And cigarettes in the 1800s were at least as dangerous and addictive as cigarettes Mr. Wilcox smoked. The simple fact of the matter is that R.J. Reynolds did not make cigarettes inhalable. They were inhalable before Reynolds ever made a cigarette. And one of the pieces of evidence you're going to hear on that is there's something called Florida Health Notes. And that's kind of like the Surgeon General of the state of Florida. And all the way back in 1906, before Reynolds produced a first cigarette, the Florida Health Notes stated that it talked about the inhalability of cigarettes, and that cigarettes were generally inhaled, and that's what made them dangerous. That was in 1906 here in the state of Florida. So it's been known for hundreds of years that cigarettes are dangerous because they're inhaled. R.J. Reynolds did not make cigarettes inhalable, nor did any other tobacco company. You also heard a lot about nicotine addiction. Mr. Gustafson talked about nicotine addiction and how it increases receptors in the brain, and I believe he said that that permanently alters or changes a smoker's brain. But the evidence in this case will not show that. The evidence in this case will show that there is no permanent change in the brain receptors. And let me explain that because it's a little bit difficult concept. We all have we all have receptors in our brain, right? And when we do something that's pleasurable, be it eat something that we really like or exercise, you've heard of terms such as runner's high, your brain releases dopamine. And there's receptors that pick up on that. And nicotine does have receptors, and they increase when a person is a smoker. However, the evidence will be that after a month or two of stopping smoking, the brain returns to normal. There is no permanent change in the brain receptors. Now, nicotine addiction does not interfere with a smoker's ability to understand the dangers of smoking. And that's for one simple reason. Unlike alcohol and some other hard drugs, nicotine is not intoxicating. And there will be no dispute about that. So nicotine does not affect or interfere with the smoker's ability to understand the dangers of smoking, and it does not interfere with the smoker's ability to make a choice or a decision to quit. And finally, nicotine addiction does not prevent smokers from quitting permanently. And you will hear that any smoker, including addicted smokers, heavily addicted smokers, heavy smokers, any smoker can quit. It takes motivation and persistence. You have to try, you have to keep trying, and you have to be motivated. Now, I want to talk a little bit also about filtered and light cigarettes, because Mr. Gustafson spent some time talking about that, saying that filters didn't make cigarettes any safer, and that light cigarettes weren't any safer, and that cigarette companies, I think he said, tried to get people to switch based on their advertising. They told smokers it was healthier, and he showed you some ads. But let's talk about the facts that you're going to hear in this case. You're going to hear that the public health community encouraged R.J. Reynolds and other cigarette companies starting in the 1950s, and they continued through the 1980s. They encouraged them to develop filtered and low-tar light cigarettes. And not only did they encourage the companies to develop them, they encouraged smokers to quit, to use them. First of all, always they told smokers, hey, you shouldn't smoke, smoking's bad for you, it's dangerous. But then they also said, if you don't quit or don't want to quit, switch to low-tar or filtered cigarettes. And we're going to see some examples of that here in a minute. But the public health community is the one that told smokers they should switch to low-tar and filtered cigarettes. And the reason why they told smokers that is because they had conducted a number of epidemiological studies that showed that smokers of lower tar and filtered cigarettes had less disease risk than smokers who either smoked unfiltered cigarettes or high tar cigarettes. There were studies, and there was a consensus in the public health community at the time Mr. Wilcox smoked these cigarettes that they were safer. And the public health community determined that they were safer, and they advised smokers to use them. And not only did they advise them to use them because they might be better for your health, but they also did studies that showed that smokers of light and filtered cigarettes had an easier time quitting than those who remained on the unfiltered or high-tar cigarettes. And you'll see evidence of this, how the public health community encouraged smokers to switch. The tobacco company ads that you saw up here for Salem Lights, I believe they said, Salem Spirit, you've got what it takes. That is what you're going to have to contrast versus some of the things I'm going to show you later from the public health community that come out and say you need to switch to light cigarettes. So keep that in mind as you hear the evidence in this case. So now that we've cleared the air about some of the things that the evidence may show in this case, I want to talk to you more about Mr. Wilcox. And the reason why we know so much about Mr. Wilcox is because before we come into court, as Mr. Gustafson told you, we have the opportunity to take depositions. And we take depositions not only of experts, as you've heard, but we take depositions of friends and family members. And what we've learned is that this is going to, it's going to be a long trial. You guys have given up a lot of your time to be here, and we've been told it's going to end in 2 weeks. But it really boils down, everything you hear really boils down to 5 fundamental facts. And we know these 5 fundamental facts from the depositions taken in this case. And if I can actually manhandle these boards, I will show you these 5 fundamental facts. Mr. Gustafson talked a lot about tobacco company conduct and the effect that that conduct had on smokers in general. But the evidence in this case will show that fact number 1 is that Mr. Wilcox did not start or continue smoking because of anything R.J. Reynolds said or did. You heard a lot about this campaign of doubt that the tobacco companies created, according to Mr. Gustafson, where we were trying to hide the dangers of smoking and the addictiveness of smoking. But fundamental fact number 2 is that the evidence undisputably will show that Mr. Wilcox understood the dangers of smoking for decades and never questioned the risks. He never voiced an opinion, I don't know what to believe.
Violation order and limiting on silence as an admission.
Sustained.
Okay. So the evidence will show that Mr. Wilcox understood the dangers of smoking for decades and never questioned.
Objection, Your Honor. Silence objection.
Sustained.
Okay. The third fundamental fact is that Mr. Wilcox did not make a serious effort to quit until 1992 when he was able to quit on the first day he tried. And we're going to talk about that in detail, but you heard that Mr. Wilcox tried various things over time. You heard about a hypnotist, you heard about an aqua water filter, you heard about trying to cut back. Never did Mr. Wilcox go 24 hours without smoking a cigarette. And that's an important fact that you'll hear about in this case, because the Surgeon General has said that a serious quit attempt by a smoker is one where the smoker refrains for 24 hours. Well, Mr. Wilcox never refrained from smoking for even 24 hours when trying to quit cigarettes. All of the things that he did, the gum, he continued to smoke while he chewed the gum. The aqua filter was a filter that went on the cigarette. He continued to smoke. And it wasn't until 1992, as Mr. Gustafson described, he got the patch. And he didn't know if the patch was going to work or not, but he put that patch on and he told his friends and family members, I'm going to quit. And he did. According to his son Robert, he quit for 4 to 6 months until the unfortunate events of Hurricane Andrew and his home was destroyed, and he resumed smoking. The fourth fundamental fact is that plaintiff cannot prove that Mr. Wilcox died from a primary lung cancer caused by smoking. And I'm going to talk about that in detail as we go forward. And the fifth and final fundamental fact is that plaintiff admits that Mr. Wilcox was a legal cause of his own death. Now, some of the other things we've learned in taking depositions in this case. Some of the words Mr. Wilcox himself used. Now, Plaintiff Robert Wilcox was asked in his deposition if he ever asked his father to quit smoking. And he said he didn't because he had asked him to change his behavior in another way, and his father told him to mind his own business and don't ever question me again, and he thought that the response about smoking would be the same. His brother Michael testified in his deposition that his father did what he wanted to do. And Mrs. Wilcox testified that things were done his way. And again, Robert Wilcox testified in his deposition that Mr. Wilcox didn't want to have anybody tell him he shouldn't smoke. Those are the words from Mr. Wilcox and the testimony you're going to hear in this case. Now, I want to talk briefly about the Engle findings because they're serious. We talked about them in voir dire, and as Judge Lindsay told you, the Engle findings are what they are. We're not going to question them. The words are there, but it's important to know what they do and do not do. And you've heard a little bit of instruction on that from Judge Lindsay this morning. But keep in mind that the Engle jury heard nothing about Mr. Wilcox. The Engle findings do not establish that Mr. Wilcox had a primary lung cancer caused by smoking. The Engle findings do not establish that Mr. Wilcox was addicted to nicotine or that addiction to nicotine was a legal cause of his cancer and death. And the Engle findings do not establish that Mr. Wilcox was a class member. You were instructed on that. And the Engle findings do not establish that anything R.J. Reynolds said or did prevented Mr. Wilcox from knowing that smoking was dangerous. And the Engle findings do not establish that anything R.J. Reynolds said or did caused Mr. Wilcox's death. And importantly, you have to keep in mind that the Engle findings do not come into play at all in this case, unless and until you find that Mr. Wilcox was a member of the Engle class. Now, talking about the Engle class and what plaintiffs have to prove, there are essentially three hurdles to proving that Mr. Wilcox is a member of the Engle class. And those are as follows. The first one is medical causation. Plaintiff must prove Mr. Wilcox died from primary lung cancer and it was caused by smoking. The second hurdle, if they get past that, is that plaintiff must prove Mr. Wilcox was addicted to nicotine. And the third hurdle, if they get by the first two, is that it is addiction causation. And that's plaintiff must prove addiction was a legal cause of Mr. Wilcox's cancer and death. And remember the instruction I read you a little bit earlier and that Judge Lindsay already gave you, that's the but-for instruction. But for the addiction, Mr. Wilcox would not have gotten cancer and died. Another way to think about it is, did his addiction force him or compel him to smoke until he got cancer and died?
This states the Engle verdict.
All right. Sustained. Next slide.
Okay. Before leaving this, all three of these hurdles. Excuse me.
All right, counsels, please direct your comments to the court. Next slide, please.
Okay.
And we're already on it.
Now, plaintiff admits that Mr. Wilcox's acts or omissions relating to the frequency and duration of his efforts to quit smoking were a legal cause of his death. That was an instruction you were given by Judge Lindsay earlier today. And specifically, Judge Lindsay told you that plaintiff has admitted that Mr. Wilcox was partially responsible for causing his own injuries and death. Specifically, plaintiff has admitted that Mr. Wilcox's own acts or omissions related to the frequency and the duration of his efforts to quit smoking were a legal cause of his cancer and death. That's undisputed, and you've been instructed on that. And that's important to keep in mind, that the plaintiffs have admitted that his his actions were a legal cause of his own death, as you hear the evidence in this case. Now, if you get past class membership, which we submit that you should not, and we're going to explain that further, the next issue you'll have to decide is whether or not plaintiff has met their burden of proof to prove reliance and legal causation on their claims for concealment and agreement to conceal. Now, legal causation, you were instructed on it today, but it's kind of a difficult concept. We've talked about it, the but-for standard, but I like to think of it sometimes as a chain, and the chain remains broken unless plaintiff supplies the links showing the connection between any concealment or agreement to conceal and Mr. Wilcox's death. The evidence is not going to provide them with those links in this case for one fundamental reason. Mr. Wilcox never questioned the risks of smoking. Now, you will see documents in this case. Mr. Gustafson showed you some in opening statement, and there are documents in this case that clearly people wouldn't agree with today. But the question is not whether or not those documents are bad or ugly, because some of them are, but the question is whether or not plaintiffs can link what's in those documents to anything that Mr. Wilcox did or said. And the evidence will not provide that link, and they won't be able to meet their burden of proof on that, because you can't conceal something from someone who already knows it. Now, those are the legal claims in this case, and I'm going to take you on a little bit of a mini tour of history to talk about the fact that the dangers of cigarette smoking and the fact that it could be difficult to quit or addictive was known throughout Mr. Wilcox's lifetime and even before he was born. And you're going to hear a lot of evidence about that in this case. But first, I think it's important to point out and note that for hundreds of years, it has been known that cigarette smoking causes disease and shortens life. It has been known that nicotine is a drug that can cause addiction to cigarettes. And it has been known that smoking can be very difficult to quit. And the reason we know that is because there's things in the popular press, there's scientific articles, but back as far as 1867, people started referring to cigarettes as something called coffin nails. You may have heard that term, but as early as 1867 until today, people refer to cigarettes as coffin nails. And what that means is that when you smoke a cigarette, you're putting another nail in your coffin. And that says it all, because essentially you're shortening your life with every cigarette that you smoke. Now, the information about the dangers of smoking changed over time. In the beginning, it was things like coffin nails and observations, but you'll hear that there's science developed, especially in the 1950s. The science was developing as to whether or not smoking was linked to cancer. And we're going to talk about that. But it may surprise a lot of you to know, because you might have heard about the prohibition of alcohol, that there was a time, starting in 1892, where the majority of states, or 22 states, considered banning the sale of cigarettes. In 16 states, including Florida and Illinois, where Mr. Wilcox was born, actually passed laws to ban the sale of cigarettes. It was kind of a cigarette prohibition. Part of that was based on morality reasons. Didn't think people should smoke. But also part of that was based on the fact that smoking was dangerous. And all of those laws eventually were repealed by 1930. And instead, what the states decided to do, such as Illinois and Florida, is they enacted other laws. And the laws they enacted were that they made it illegal for anyone under the age of 18 to smoke. Now, there was some suggestion by Mr. Gustafson, I believe, that the invention of the modern cigarette was the reason why people, well, let me rephrase that, the suggestion that people didn't know that smoking was dangerous or addictive until the invention of the modern cigarette. And the fact of the matter is that for years before R.J. Reynolds produced a cigarette, it was known that smoking was related to disease and that it was addictive. If you look at the Manual of International Classification of Causes of Death, that was the official causes of death manual in the United States, all the way back to 1902, they had a cause of death called smoker's cancer. Now, at the time, they were talking about oral cancer because there were not a lot of ways to detect lung cancer at that time. But the crux of the issue is that back in 1902, in the United States, there was a cause of death noted as smoker's cancer. The relationship between tobacco use and cancer was known. And in 1915, there was a report done for the Surgeon General of the United States. What they did is they were examining or looking at the conditions of garment workers in New York State. Back then, garment workers was a big industry in the United States, and they were looking at the conditions in which those workers worked. And what they found is that those workers smoked cigarettes. And they found that they were addicted to cigarettes. And back in 1915, there was a report to the Surgeon General finding that smoking was addictive. So you see that even before Mr. Wilcox was ever born, it was known that smoking can cause disease and smoking was addictive. And that information continued throughout his lifetime. And one of the ways that information was communicated was through something called the Reader's Digest. Many of you may have never seen a Reader's Digest, but there was a time in this country where the Reader's Digest was the most popular magazine in the United States. 1 in every 4 households subscribed to the Reader's Digest. And what's important about the Reader's Digest, and you'll see a lot of them in this case, because the Reader's Digest, the owners of the Reader's Digest were very anti-tobacco. In that magazine, there was never an ad for a cigarette. There was never any tobacco company ads. They didn't like tobacco, the owners, and so they wouldn't let advertising, but they also ran a number of publications that talked about how cigarette smoking is dangerous, can cause cancer, is addictive, and how you can quit. And what's important about the Reader's Digest is at the time that this was disseminated throughout the United States and all these homes were getting it, it was like a hardcover magazine. It's not like a magazine we think of when we go to the grocery store or we're at CVS checking out and we see people. It was hardcover and it was kept around people's homes as a resource. It sat around doctors' offices forever. And the United States Surgeon General actually recognized Reader's Digest for its profound influence on informing the American public about the dangers of cigarette smoking. And they started this before, and at the time Mr. Wilcox was born in 1924. In this article, they found that tobacco is injurious to the human body. Its use sometimes induces cancer. That's all the way back in 1924, and we're going to see how that continues throughout time through the Reader's Digest. These are just some of the examples of some information that was available before Mr. Wilcox was born. And we're going to talk about, I'm going to go through some timelines so we can talk about exactly the information that was available throughout his lifetime. So I'm going to start with the first timeline, which is 1924 when he's born through 1941. What you see is that in 1924, Mr. Wilcox is born in Winchester, Illinois. And as we just discussed a little bit ago, at the time he was born, Illinois had law that you couldn't smoke under the age of 18. You're also going to hear evidence in this case that Illinois schools were teaching the dangers of smoking. In fact, there was a curriculum guide in 1925 in Illinois that talked about how teachers need to especially emphasize how their students should avoid tobacco and avoid disease. As we talked about with Reader's Digest and other things, warnings about smoking were in the news and popular culture throughout this time, and there were public warnings about cancer and addiction. Now, I have up here that Mr. Wilcox moves to St. Louis, and you heard Mr. Gustafson talk about how he spent time between his aunt's house and his father's home. And we're going to note some of the places that Mr. Wilcox lived throughout his life because it's important to know what kind of information he was exposed to. But the last line, kind of the blue-teal line that I want to point out to you, is very important because you heard Mr. Gustafson talk about the meeting at the Plaza Hotel in 1953, and he said it was at Christmas time, and there was, in his words, a conspiracy hatched where they were going to conceal information from smokers about the dangers and addictiveness of smoking. But what's very important about this period from 1924 to 1941, when information was out there, is that there are no allegations of conspiracy to conceal information about the dangers and addictiveness of smoking. No allegation that companies were hiding anything during this time. Now, I want to talk a little bit about some of the specific things that were available in Mr. Wilcox's life. These are some textbooks from Illinois where he went to school. And in 1928, you'll see the textbook says heavier users of tobacco show a death rate 57% higher than abstainers. That's in 1928. In 1932, textbooks from Illinois said that the average life is shortened as much as 7 years by the use of tobacco. The lungs also suffer directly from the effects of tobacco smoke if it is inhaled. That's in 1932. Not only talking about the dangers of smoking in school textbooks, but talking about inhalability as well. Now, during this period, the 20s and 30s and 40s, all throughout this time, Reader's Digest continues to publish articles about the dangers of smoking. And we'll see those during trial. But there's news, there's the Reader's Digest, there's public warnings, there's all sorts of information available to Mr. Wilcox during this time. Now, I want to go to the next timeline, which is 1942 to 1947, and talk about what was going on in Mr. Wilcox's life during that period. In 1942, as Mr. Gustafson tells you, he enlists in the Marines. He was 18 years old at the time. And important at this time, there's no allegation still of conspiracy to conceal information. Now, you still have the warnings about smoking in news and popular culture, and there's public warnings about cancer and addiction. And what's new up here is that there's also warnings about smoking that appears in the military newspapers. And we're going to talk about that in some detail because the evidence in this case is going to show that Mr. Wilcox kept up with current events. He read newspapers daily. He read them cover to cover. He didn't read them just for the sports section. He got 2 newspapers when he was in the United States. He got the morning newspaper and he got the evening newspaper back in the time when there were 2 newspapers available. But he read newspapers, he digested the information, he read them cover to cover, he watched the news. He watched the local news, the national news, and then the late night news before he went to bed. And we're going to talk about the warnings that appeared in the military newspapers because when he was overseas, he received just the Stars and Stripes. And there were articles about the dangers of smoking appearing in that newspaper as well. And what you're going to see is in 1945, it says up there, the first witness you're going to see in this case, or hear in this case, that saw him smoking was Mrs. Wilcox. That's in 1945 when Mr. Wilcox was 21 years old. That's the first witness that's going to come in here and tell you that they saw him smoke. Now, he marries Mrs. Wilcox in 1946, and in 1947 she gets pregnant with their first son, Michael. And I find it very interesting because Mr. Gustafson said something about doctors didn't even warn pregnant women to stop smoking when they were pregnant. But in 1947, the testimony in this case will be that Mrs. Wilcox's doctors told her she needed to quit smoking. She was a smoker. She needed to quit smoking because it could harm her baby in 1947. And she did just that. She quit smoking while she was pregnant. Their son, Michael, was born in 1947. And in 1948, Mr. Wilcox re-enlists in the military, and they moved to North Carolina. A couple years later, they moved to Tennessee. And what you'll hear in this case, and we're going to talk about it, is in the 1950s, there was a lot of information starting to come out about the dangers of cigarette smoking. Mr. Gustafson talked a little bit about some of the scientific studies, the mouse skin painting studies, etc. And that had a profound impact because millions of smokers started to quit. Millions of smokers started to quit, and importantly, at no time does Mr. Wilcox even make an attempt to quit smoking during this period and much further, as we'll discuss later. Now, you can see up there during the publication of the Frank Statement, in 1953 to 1955, Mr. Wilcox is in Japan. In 1954, the first tobacco lawsuit, similar to this one, was brought where someone claimed that they were harmed by smoking cigarettes. In 1955, Mr. and Mrs. Wilcox moved back to Florida, where they stayed for a couple years until 1957, when they moved back to Tennessee. Now, we have up here that Mr. Wilcox, the first witness in this case, saw Mr. Wilcox start smoking in 1945, and that is true. However, you also heard that, and you saw a medical record where Mr. Wilcox told one of his doctors that he started smoking at the age of 8. But I want to talk a little bit about what we do and do not know about Mr. Wilcox's smoking from the time he was 8 till 1945, some 13-year period. There is not going to be a single witness that will come in here and tell you anything about Mr. Wilcox's smoking for that 13-year period. No one saw him smoke. No one knows how much Mr. Wilcox smoked during that period. No one knows when Mr. Wilcox started smoking every day. No one knows what brands of cigarettes Mr. Wilcox smoked at that time. And no one knows why Mr. Wilcox started smoking. And it's important because that 13-year period is the period in which plaintiff's expert will tell you that Mr. Wilcox became addicted to cigarettes. During that 13 years, their witness is going to tell you that's when he became addicted. Now, we're going to talk about it. We don't think he was addicted, but that's their evidence. And we don't know anything about what he was smoking or why he was smoking during that 13 years. The evidence is going to be that there is no evidence that R.J. Reynolds had anything to do with Mr. Wilcox smoking, because there's nobody that's going to tell you that. Now, I talked about the Stars and Stripes and what was known and reported in the Stars and Stripes, and let's look at what was in the Stars and Stripes in the 1940s. And I want to make something very clear. The Stars and Stripes was the newspaper military received overseas. It was the only newspaper they could receive overseas. They didn't get local newspapers. They didn't have the internet, etc. But what you do see is that the types of articles that were appearing here in the United States about the dangers of smoking were being printed in the Stars and Stripes. Here's an example from the St. Louis Blvd Democrat, where Mr. Wilcox's family was. There was an article about smokers inhale tar substances that can produce cancer. 2 days later, September 6, 1947, the same article, different title, is published in the Stars and Stripes. It says, "Doctor warns cigarettes cause cancerous tar." An article, both of those articles contain the following statement. The pack-a-day smoker in 10 years inhales 8 quarts of tar substances able to produce cancer. Tar contains carcinogens, which have been known, even in small amounts, to produce cancer in animals and sometimes in humans. Same articles that were being published here in the United States were being published to servicemen and women overseas and appearing in the Stars and Stripes, and we're going to see some more examples. But there's one also from 1948 up there that says cigarettes said disease cause. It's a little awkwardly worded given today's language, but that's what was appearing in 1948 in the Stars and Stripes. So it was no secret from or hidden from servicemen overseas. They were reported by the Stars and Stripes, and they received it. Now, not only did the Stars and Stripes, the St. Louis Blvd Democrat, continue to talk about the dangers of smoking, but you have the Reader's Digest continuing as well. And I'm not going to go through all of these titles, but it's important to note that the Reader's Digest talked about specifically things like lung cancer. There's a title up there, The Growing Horror of Lung Cancer. And then there's one that's just, you can't avoid reaching the conclusion that it is a profound statement because it's a title called Cancer by the Carton. And you're going to hear witnesses in this case talk about that. That pretty much says it all. That when you buy a carton of cigarettes, you are buying a carton of cancer. The title says it all. Now, in the 1950s, we've heard that some things started to change and there were some scientific studies starting to come out. And what happened was there was a Dr. Winder in 1950 who did something called epidemiological studies. And what those are studies where you take one group of people and compare them with another group of people. And he compared the group of smokers with a group of non-smokers. And what he found was that smokers developed lung cancer and other diseases at a higher rate than those who didn't smoke. That was the first epidemiological study that really made the link, and that was in 1950. And it was pretty big news at the time. And you're going to hear about how that was big news. But it was big enough news that it appeared not only in papers throughout the United States, but it also appeared in the Stars and Stripes. And you'll see there's several articles about it, but in 1952, there's an article that says smoking ups lung cancer study shows a 4-year study showed death from lung cancer increases as tobacco smoking increases. That was 1950, and that was first epidemiological study. But Dr. Winder didn't stop there. In 1953, he went on with a gentleman named Dr. Graham, and they performed some mouse skin painting studies. And you heard Mr. Gustafson talk a little bit about those, and he talked specifically about this and the publicity that those mouse skin painting studies got in Life magazine. They weren't just reported in Life magazine, but if anybody recalls seeing a Life magazine, they were big magazines, and they had pictures, and people loved it. It was a very popular magazine at the time, and it was known for its beautiful pictures, and it was also known for its stories. And here they have a very non-beautiful picture, but a very dramatic picture that shows how the scientists would shave the backs of mice, and they would put tar from cigarettes on the backs of those mice. And what they found for the very first time was that tumors grew from the backs of the mice that had been painted with tar from cigarettes. That was the first animal study that made national news, and it made national news because it was a very important study. And here's an example of how it was covered in Life magazine. That's 1953. Now, 1954, Mr. Wilcox's newspapers, both in Memphis, the Stars and Stripes, they continued to talk about studies about the dangers of cigarette smoking. And you'll see this one that talks about cigarette smokers die sooner than other men aged 50 to 70, and they die mainly from heart disease and cancer, an American Cancer Society report indicates. For men who smoked a pack a day of cigarettes or more, the death rate from heart disease and cancer is at certain ages double that of non-smokers. That's just an example of the types of coverage that was appearing in the newspapers that Mr. Wilcox read cover to cover on a daily basis. Now, starting in the 50s, of course, the print wasn't the only thing that was covering the dangers of smoking. There was TV, and TV was becoming more accessible and more popular, and it was a very good way to get messages across. And some of you may remember when there were only 3 television channels or stations. It was ABC, NBC, and CBS. And you also didn't have remote controls, no CNN or anything like that. And at the time, all 3 of those channels or stations covered the dangers of smoking. And there was a show in the 1950s called See It Now. And that was a gentleman named Edward R. Morrow, who is much like Anderson Cooper is today. It was kind of a documentary. And in 1955, this was shown on See It Now.
Good evening. This is See It Now, produced by the partnership of Friendly and Morrow. Tonight, the first of 2 reports on cigarettes and lung cancer.
In 1952, Drs. Hammond and Horn of the American Cancer Society began an extended study of the smoking habits of American men. Here is Dr. Hammond reporting on the results of the first 2 years.
It is now established, in my opinion, beyond a reasonable doubt, that cigarette smoking greatly increases the probability of developing lung cancer. In my opinion, people should be warned of the danger, and they are being warned. What they then want to do, whether they wish to smoke or not, is their own business.
That was 1955, and we're going to hear evidence in this case about some additional things that ran in TV and newspapers, etc. But I'm going to jump to 1957 because there were some congressional hearings in 1957, and some of the public health officials came and they testified in front of Congress, and they were talking about how the public is being informed about the dangers of smoking. And at the time, the Surgeon General of the United States was a gentleman named Leroy Burney, and he stated that our position is that we have informed the public through the excellent coverage of the press, radio, and TV. That's 1957, what he was saying about how they've informed the public about the dangers of smoking. Then the director of the National Cancer Institute, Dr. John Heller, said that newspapers, radio, TV, and other media have done an excellent job covering this problem, and a very objective job. This is an exceedingly valuable way of informing the public. Now, I want to jump up and move away from 1957, where I just ended, with the congressional hearings, and look at Mr. Wilcox's life from 1958 to 1969. And as you can see, when I put these boards up here, they get a little bit more information on them as the decades move forward. So, what you're going to hear, the evidence in this case, is that this is a decade, 1958 through 1969, that were filled with warnings about the dangers and addictiveness of cigarettes. There's warnings about smoking in the military newspapers we've seen. There's warnings about smoking in the news and popular culture. There's public warnings about cancer and addiction. And all of those warnings did one thing. It also turned it into a decade where millions of Americans quit smoking. You will see that in 1964, at that time, from 1954 to 1964, that 10-year period, 17 million smokers quit. And from 1964 to 1969, 13 million smokers quit just in that 5-year period. And importantly, at no time during this does Mr. Wilcox quit smoking or even try to quit smoking. And he doesn't try with the millions and millions of other smokers, and importantly, he doesn't try with his wife. Mrs. Wilcox resumed smoking after she gave birth to Michael, but she got pregnant with Robert Wilcox in 1965, and she quit, and she stayed quit for good. So, lots of warnings about smoking, lots of quitting, and then we have here some information about where Mr. Wilcox was living at the time. In 1959, he was in North Carolina. In 1962, he was deployed to Japan. And in 1963, he retires from the military and moves permanently to Florida. Now, during the time he was in the military, he was serving as an aircraft mechanic for that period. And after he retired, as you heard, he took a job with Eastern Airlines where he continued being an aircraft mechanic for Eastern Airlines here in Miami. Now, in 1964, something important happened, and we're going to talk about that in a minute. But the Surgeon General determined, they issued a report, and they determined that smoking causes lung cancer in men. And I'm going to talk about that in some detail here in a second. But after that report, in 1966, the warning label went on every pack of cigarettes. It doesn't matter if you call it a warning label or a cautionary label. The fact of the matter is that every pack of cigarettes that Mr. Wilcox smoked from that period until 1969-70, when the warnings changed, stated that caution, cigarette smoking may be hazardous to your health. Now, in 1967, Mr. and Mrs. Wilcox and their family moved to Miami. And after the 64 Surgeon General's report, after the warning labels go on cigarettes, something else started to happen. And that's that public health community started something called PSAs. That's up here. You probably don't know what it means. It's public service announcements. And what they started to do was take out advertisements of their own where they talked about the dangers of cigarette smoking. And we're going to see some of that in this case. And finally, I want to talk about the fact that during this period, the public health communities not only doing the PSAs and warning smokers to quit smoking, they're also urging smokers to switch to filtered cigarettes. During this entire time, the public health community is urging smokers to quit, and if not quit, switch to filtered cigarettes. During this entire time, Mr. Wilcox smokes Camel unfiltered cigarettes. He doesn't listen to the advice of the public health community. Now, I know you're tired of seeing newspaper articles, so I'm going to do this last one because it was interesting only because it's from a newspaper where he lived in Memphis, and it's a study of veterans. And this study of veterans showed that almost 2,000 ex-servicemen in the United States shows those who use cigarettes regularly die off much faster than non-smokers. Over a 2.5-year period, deaths among cigarette smokers were 58% higher than among abstainers. A paper that Mr. Wilcox read, where he lived, talked about a study of veterans in 1958, and it reached the conclusion that cigarette smoking causes death. Now, during this entire period from 1958 to 1969, warnings continued in magazines, including Reader's Digest. Here's some of the covers and titles: Lung Cancer and Cigarettes, How to Stop Smoking, More Bad News for Smokers. And you're going to see that throughout the trial, that Reader's Digest and other magazines talked about the dangers of smoking. And then, as I said, in 1964, something else happened. And that's the Surgeon General issued this. This was the first report that the Surgeon General issued on the issue of smoking and health. And in this report, the Surgeon General reached a conclusion that smoking causes lung cancer in men. And that was big news. As Mr. Gustafson said, it was national news. It made headlines in newspapers. It was on TV, and we're going to talk about that. I'm going to show you some of that here in a second. This book, which is filled with scientific studies, became a bestseller. And when the report came out, what happened was the Surgeon General held a press conference. And he held a press conference in every single solitary network. Remember, there's only 3 at the time. All of them aired a special 1-hour-long program about the release of the 1964 Surgeon General's report. And this is an example from Harry Reasoner following the 1964.
This is a CBS News Extra on smoking and health. The findings of the Surgeon General's Committee.
Almost from the moment that cigarettes were introduced, they were attacked. But the attacks took a new turn 10 years ago and culminated in today's report by the Surgeon General's Committee. This, in summary, is what the committee says. Cigarette smoking is a major cause of lung cancer in men, and data on women smokers points the same way. Cigarette smoking is a significant cause of cancer of the larynx, and probably the most important cause of chronic bronchitis. Cigarette smoking may be related to other lung diseases. Male smokers have a much higher death rate from heart disease, although it's not proven that smoking is the cause. On the question of fillers, the committee says there is no evidence that they do any good, but it didn't exclude the possibility that an effective filler might be developed. In short, the committee says if you smoke cigarettes, you increase your chances of dying early. The sooner you start, the more you smoke, the more you inhale, the worse your chances are. In this kind of a country, it comes down to you whether you like it or not. No one is going to forbid an adult to smoke, and it is now quite clear that no one is going to tell him it's good for him either. The decision is his, the decision and the health that may depend on it. This is Harry Reasoner. Good night.
And that's the coverage on the news. Clearly, the newspapers picked it up as well, and I'm not going to belabor the point, but in the Miami News and the Miami Herald, those were the 2 different newspapers, morning and evening, that were in Miami that Mr. Wilcox received. Front page news for 2 days straight talked about the 1964 Surgeon General's report and what was found in that report. And what's amazing is that after that report, millions of people started to quit, as we talked about on this timeline. And the news started covering quitting of smoking. Not only did they cover, they told you, here's some steps on how you can try to quit. And here are some clinics here in Miami where you can go to learn how you can quit smoking. And these are just a sample of the articles that appeared in the Miami Herald and the Miami News talking about how you can go to a clinic or what you can do to quit smoking. And there will be no evidence in this case that Mr. Wilcox did any or took any of this advice. And in 1965, talking about the 1964 Surgeon General's report, the Florida Health Notes stated the following. Nearly all Floridians have heard about the Surgeon General's report on smoking and health, which was released in 1964. That was their conclusion 1 year later. And remember, Mr. Wilcox was living in Florida at the time of the release of the report. Whoops. Going a little too fast. 1966, we talked about the cautionary or warning statement, depends on what you want to call it, but it was on every pack of cigarettes. And not only was it on every pack of cigarettes, it was reported about in the newspapers. The Miami Herald and the Miami News reported the fact that that warning label went on cigarettes in 1966. And not only did the newspapers pick up on it, but public health community people such as the American Cancer Society, they started advertising to smokers and saying, hey, there's a warning on cigarettes now. And here's an example. Congress has acted, the next step is yours. Telling smokers, here's a warning, you need to quit. Now, in 1968, Dr. Daniel Horn, who at the time was charged with informing the public in the United States about the dangers of smoking, stated the following. He said, you could stand on a rooftop and shout smoking is dangerous at the top of your lungs, and you would not be telling anyone anything that they didn't already know. And that was in 1968. Now, I talked a little bit about these public service announcements that started to run in 1969, and they continued throughout 1970 and later. And I want to show you some examples.
The moment you stop, in most cases, the effects of smoking will begin to reverse themselves, till your lungs are nice and clear again.
Save our life. This message is brought to you by the American Cancer Society.
Divided into the bad and the worse. This is bad. This is worse. This has twice as much tar and nicotine. There's as much tar and nicotine in one of these as in two of these. That's quite a difference. As a matter of fact, you can buy as much as 34 milligrams of tar in a cigarette, or as little as 2. As much as 2.1 milligrams of nicotine, or as little as 0.2. With 130 different cigarettes on the market, you can certainly find one with a lot less tar and nicotine than the one you're smoking. Not a good cigarette, just one that isn't as bad. The Public Health Service has a free tar and nicotine list that shows them all. Send for it. Look them up. If you must smoke, at least bad is better than worse.
Cancer experts said today that the new low-tar and low-nicotine cigarettes are safer than regular cigarettes, although people who smoke these cigarettes still have far higher death rates than people who don't smoke at all. This news comes at a time when Americans are smoking more cigarettes, more than 600 billion of them last year. Brian Ross has more on the story.
Low-tar and nicotine cigarettes now account for 11% of all the cigarettes smoked in the country. And sales have grown in the belief such brands are less likely to cause lung cancer and heart disease. The American Cancer Society says today's report is the first solid proof that low-tar and nicotine cigarettes are safer.
Tar and nicotine is being further reduced. And it is far better that people don't smoke. But if they're going to smoke, as many people are just plainly going to do, then they're better off smoking a cigarette with low-tar nicotine than with high-tar nicotine. I'm hoping that people who never smoke anything but the low-tar nicotine cigarettes, by the time they reach 40, 50, 60, that they will not have the death rate of cigarette smokers of my generation.
The Cancer Society Society report is based on a 12-year study of tens of thousands of smokers. Low tar and nicotine cigarette users had a 26% less chance of lung cancer and a 14% less chance of heart disease than those who smoked high tar nicotine cigarettes. But the study also found that smokers of low tar and nicotine cigarettes had a death rate much higher than those who don't smoke at all. Brian Ross, NBC News, New York.
Now I think it's over. And you're going to see evidence like that in this case, both of the PSAs and of the public health community telling smokers to switch to low tar and light cigarettes. I want to move on and talk about the next decade in Mr. Wilcox's life, and that's 1970 to 1982. In 1970, you'll hear evidence that the warnings on cigarettes changed. And the warnings became that warning, the Surgeon General has determined that cigarette smoking is dangerous to your health. And also in 1971, cigarette ads were banned from TV and radio. In the same year, the warnings that you see, the Surgeon General's warnings, were required to be on every print ad advertising cigarettes. Now, you'll hear that during this decade, not only were the warnings on every packs of cigarettes and all the advertising, there continued to be warnings in the popular culture and in the news, and the public health community continued to urge smokers to switch to low tar and filtered cigarettes, as you just saw. But the warnings were out there, and Mr. Wilcox also received a very personal warning in 1974, and that's when he had a heart attack. Now, you're not going to hear any claim that the heart attack was caused by smoking, or plaintiff is claiming anything in this case about his heart attack. But what you will hear is that in 1974, Mr. Wilcox's doctors tell him that he needs to quit smoking. They tell him, you had a heart attack, you need to quit smoking. In the same year, his wife, Mrs. Wilcox, for the first time, asks her husband to quit smoking so that he can live a longer life. Personalized warnings. During this entire time, millions and millions of people are still quitting smoking. So you see in 1979, 30 million people had quit since the 1964 Surgeon General's report. And during this time, from 1970 to 1982, the evidence will show that Mr. Wilcox does not try to quit smoking. Mrs. Wilcox will testify that Mr. Wilcox did not try to quit smoking until he retired from Eastern Airlines, and we'll talk about that in the next timeline. So he's not trying to quit smoking 9 years after he's been told that he's had a heart attack and he needed to quit smoking. Now, in 1976, you'll see on this that Salem lights were first introduced. That's what Dr. Proctor will tell you, is that Salem lights in 1976 were first introduced, and that's 2 years after Mr. Wilcox has his heart attack. And it's also during the time that the public health community is urging smokers to switch to low tar and filtered cigarettes. And you saw the ads, or you saw the PSAs that we just showed, where it was clear that what the public health community was telling smokers. And I'll ask you, as you see the evidence in this case, contrast that with the advertising that Mr. Gustafson and plaintiffs will claim caused smokers to switch to low tar cigarettes. Remember the Salem ads. Salem Spirit, you've got what it takes. Compare that with the public health community saying, quit smoking now. And if you're not going to quit, switch to low-tar filtered cigarettes. Now, at the same time they were telling smokers to switch to low-tar and filtered cigarettes, you'll hear that there's still newspaper articles that talk about, okay, we're switch, but filters aren't the answer. You just heard that from the television clip as well. Filters aren't the answer, and the only safe cigarette is no cigarette. That was still appearing in newspapers throughout this time. And throughout this time, you were still having newspapers report on how you can quit smoking, where you can go to get help quitting smoking. And right here in Miami, both in the Miami Herald and the Miami News, there's a number of articles that talk about how to quit and where to go to get help. And again, the evidence will be that Mr. Wilcox did not take any of this advice. So I want to move to the last timeline, which is 1983 to 1984. And according to Mrs. Wilcox, Mr. Wilcox retires from Eastern Airlines in 1983. And at that time, he starts trying to quit smoking, according to her testimony, because he couldn't try earlier because everybody at work smoked. That's her testimony in this case. Now, what we're going to hear is that from 1983 until 1992, as I said, Mr. Wilcox never goes 24 hours without smoking, but we'll talk about that in a little bit more detail later. But in 1983, Mr. Wilcox retires from Eastern Airlines. He also tells his son Michael, at that same year, he tells Michael, who was smoking, he needed to quit because it was bad for his health. In 1985, 42 million Americans had quit smoking cigarettes. And also in 1985, there were 4 new warnings that appeared on cigarette packs. And what I should mention is that for all of the warnings, from 1966 forward, Congress was the one who dictated the language of the warnings, where it should go on cigarette packs, and even dictated the type of print that should be contained in the warnings. Now, throughout this period, millions and millions of smokers are trying to quit and have quit. You heard 42 million. And up until 1992, Mr. Wilcox does not make a serious effort to quit smoking. And in 1992, what happens is his brother dies from emphysema, lung cancer, and heart disease. That same year, Mr. Wilcox gets the patch. He gets a prescription from his family doctor, and he's never tried the patch before. He's, according to Mr. Gustafson and the evidence, he's going to have tried other things like the gum, and he still smoked through with all that. But he puts the patch on, and before he ever does, he tells all of his friends and family, I'm quitting smoking. And he does. He quit smoking from that moment, the very first day he tried, until, unfortunately, Hurricane Andrew hit. Then he resumed smoking. Now, as you know, this timeline ends in 1994, because that's the year Mr. Wilcox passed away. You heard some that the evidence in this case will go beyond 1994. At least there's some talk about some congressional hearings that happened after 1994. And that was after Mr. Wilcox died. And plaintiff will have to prove that all of the evidence relates to Mr. Wilcox, and they won't be able to show that for anything after 1994. So I want to go back. Now that we've talked about Mr. Wilcox and what happened in his life, I want to talk about the claims, legal claims, again in this case. This is the slide you've already seen, and I want to talk about this first hurdle for Engle, what it means to be an Engle class member. And the first hurdle I want to talk about is medical causation. Plaintiff must prove that Mr. Wilcox died from primary lung cancer and it was caused by smoking. Well, what does that mean? That means that they have to prove to you something about Mr. Wilcox. They can't come in and just say smokers get lung cancer, therefore Mr. Wilcox smoked and he got lung cancer. They have to provide you evidence specific to Mr. Wilcox. And they have to provide you evidence showing that he had a primary lung cancer. And what that means is that it's a cancer that started in his lungs versus started somewhere else and metastasized or moved to his lungs. Now, it's undisputed that smokers do get cancer. But it's also going to be undisputed that only 10 to 15% of smokers get cancer. Non-smokers get lung cancer. And there are things that cause lung cancer other than cigarette smoking. And you're going to have to ask yourself what evidence was brought to you to prove that Mr. Wilcox developed a primary lung cancer because of his smoking. We're going to submit to you that plaintiff cannot prove that Mr. Wilcox had a primary lung cancer caused by his smoking, and the reasons are as follows. Mr. Wilcox's cancer did not look like a primary lung cancer, and I'm going to explain that in a little bit of detail in a second. You heard something about evidence will show that tests performed proved that Mr. Wilcox had a primary lung cancer. There were no such tests. There's absolutely zero evidence of any test performed that established that Mr. Wilcox's cancer started in his lungs. And I'm going to talk about that as well. And while other primary sites were considered for Mr. Wilcox's cancer, his prostate, his scalp, other areas, they were never investigated because after the surgery, Mr. Wilcox went downhill, and he went downhill fast. And that's what I'm going to spend a little bit of time just talking to you about. But before I do that, I want to talk about what you won't have in this case. There are a lot of medical records, but a lot of those medical records aren't available because it was a long time ago. So we don't have important things like x-rays. We have x-ray reports, but we don't have the actual x-rays that our experts on either side can look at. We don't have the CAT scans. We don't have any MRIs. And the pathology that Mr. Gustafson talked about, where they take cells from the tumor, we don't have that. We have reports from those pathologists, but in those reports, they just have their conclusions. They don't describe what they're seeing. They don't describe the cellular features. And you're going to hear from plaintiff's own expert, Dr. Villa, that Mr. Gustafson talked about. Pathologists disagree all the time. Pathology is an art, not a science, and it's very easy to get different opinions when you look at the tissue, but we can't do that in this case. There's no definitive staining, none whatsoever, that shows that Mr. Wilcox had a primary lung cancer. There's no chemical tests, there's no PET scan, and importantly, there's no autopsy, and you're going to hear Dr. Villa tell you how important that is, and that's their own expert. But let's talk a little bit about the evidence in this case. And what you're going to hear, Mr. Gustafson talked to you a little bit about this, is Mr. Wilcox went into the hospital and they had a chest x-ray and it showed something in his lung, something that shouldn't be there. They went and sent him off to get some CAT scans, and he had 2 CAT scans. Both showed a 1.2 centimeter peripheral nodule. They didn't see anything else. They saw a single nodule in his lung. And that's important because when you see a single nodule in someone's lung, and there's no other sites that you can identify, it's reasonable to conclude that Mr. Wilcox had a primary lung cancer. They did some other CTs. They examined his abdomen, and they showed that his prostate was enlarged, but they never examined that. They showed the bone scans that they did actually showed some uptake, and they assumed it was degenerative disease, but they never examined it further. And importantly, they did a CT of his head or his brain to see if there's any metastasis up there, and they noted that he had a lesion that was showing on his CAT scan of his brain, and they never investigated it. Even though his own doctor said, we need to get a biopsy of this scalp lesion, it wasn't done because he went downhill, and he went downhill quickly. So while it was reasonable for them to conclude based on the evidence that they had that he had a primary lung cancer, everything changed the moment Mr. Wilcox went to surgery, because what happened was Dr. Lamellis was his surgeon, and when he performed the surgery, he looked at Mr. Wilcox's lungs, and the CT scans might have said that there was one single solitary nodule, but that wasn't true. What you'll see from the operative report is that there were multiple nodularities noted in the entire lung, significant involvement of the left lower lobe bronchus, multiple lymph nodes. Then he decided to make a decision. He couldn't just cut out a portion of Mr. Wilcox's lungs. In fact, you'll hear evidence that Mr. Wilcox told his son Robert that his tumor was the size of a pea and he was going in to have surgery to take out that one tumor. But when they opened him up and they saw all of the cancer, they decided to remove the entire left lung. That's the pneumonectomy Mr. Gustafson talked to you about. And then when the pathologist looked at that lung, they noted cancer all over the lung as well. There was poorly differentiated subpleural adenocarcinoma in each lobe with metastasis to the lymph nodes. So why is that important, you may ask? Well, cancer can spread from any organ of the body to the lungs. And when it does spread to the lungs, what you find is that you'll have multiple nodules. Primary lung cancer that starts in the lung tends to be a single solitary nodule, like they first thought it was. But when they opened Mr. Wilcox's chest and looked at his lungs, they saw cancer everywhere. And that's, you're going to hear evidence, is consistent with a cancer that started somewhere other than Mr. Lungs and metastasized or grew to his lungs. Now, everyone agrees, and Mr. Gustafson even said that the course after this surgery was very difficult for Mr. Wilcox. He had ventilation settings that were set very high, and it caused a hole in his lung. He developed heart arrhythmias. And everyone agrees, all the experts in this case will agree that Mr. Wilcox died because of complications from this surgery. Now, I want to move on and talk about the second hurdle, and that's addiction. And plaintiff must prove that Mr. Wilcox was addicted to nicotine. Now, you're not going to get a definition of addiction in this case. That would make it a little bit easy. But what you will see is that you'll have evidence on witnesses from both sides come and talk to you about addiction and what they look at when they're determining whether or not someone is addicted. And plaintiff's witnesses will tell you that you should determine that Mr. Wilcox was addicted because he was a heavy smoker who smoked for a number of years. But the evidence will show that not all smokers are addicted, and that smokers smoke for many reasons other than addiction. So you've got the medical causation, then you have the addiction, and the final hurdle to proving Mr. Wilcox was a member of the Engle class was addiction causation. And we've talked about this a little bit. Again, Judge Lindsay provided you an instruction on this, but plaintiff must prove that addiction was a legal cause of Mr. Wilcox's death. But for his addiction, he would not have developed lung cancer and died. Now, I want to start there by talking about the millions of Americans who have quit smoking. From the 1950s, 1960s, 70s, and on, millions of Americans quit smoking. You saw that on the timeline. So, what are some of the statistics from that? You know that there's been millions of Americans who quit smoking, but over 90% of those people who quit, of those millions and millions, they quit cold turkey. Mr. Gustafson likes to talk about Chantix and the gum and the patch, etc., but 90% of those millions of smokers quit cold turkey. And he told you that 60 million Americans have quit smoking. $60 million Americans. And if you do the math, that's about 5,000 smokers every day quit. Now, why is it important? Because every smoker can quit. Heavy smokers can quit smoking. Addicted smokers can quit smoking. Every smoker can quit smoking if they're motivated and they have the persistence to try. And the question ask yourself is, was Mr. Wilcox different than any of those other 60 million Americans who quit smoking? And we know that his cigarettes were not any more addictive than other cigarettes, that his brain was not affected differently than other smokers who did quit. We know that he was not exposed to any different advertising than the other smokers who quit. He was not exposed to any different tobacco company statements than smokers who quit. And he did not smoke more than other smokers who quit. That will be the evidence in this case. You will also hear evidence in this case how Mr. Wilcox made his own decisions about smoking. He was king of the castle. He was his own man. These are words of witnesses in this case that you'll hear. Mr. Wilcox would make his own decisions. When Mr. Wilcox made a decision, everybody abided by it. Mr. Wilcox would not have listened to his family because you didn't talk to Dad about what he did. And he wouldn't allow anyone, including his wife, to take away his cigarettes until he said they could take away his cigarettes. And when Mr. Wilcox's doctors told him to stop smoking, he didn't want to see the doctor anymore. The evidence will be that no one was going to tell Mr. Wilcox what to do. Now, before 1983, when he first...
Objection, Your Honor. Violates the order and limiting on silence as an admission. Again.
Could you all come sidebar, please? counsels. You may proceed.
Now, the evidence will show that Mr. Wilcox smoked for nearly 40 years before he ever tried to quit smoking. And I want to talk about what Mr. Gustafson referred to as efforts to quit smoking that occurred before 1992 when he used the patch versus after 1992 when he put the patch on. And I alluded to this a little bit earlier, but there is never a time, at any time before 1992, where Mr. Wilcox says, I'm going to try to quit smoking, and he actually refrains from smoking for more than 24 hours. And the Surgeon General has said a serious quit attempt is one where the smoker stops smoking for at least 24 hours. All of the things that he did, the aqua filter, or whatever it was, the gum, he didn't change his smoking behavior. He continued to smoke on a daily basis. He never threw out his ashtrays. And Mrs. Wilcox was the one that bought the cigarettes in the house. She bought all the cigarettes that Mr. Wilcox smoked throughout time because she went to the grocery store. And he did not want or allow her to take cigarettes out of the house or stop buying those cigarette smoking. And he never announced that he was going to quit at any of those times before 1992. But what happened in 1992, as I've described a little bit earlier, is he got the patch, he put it on. Before he ever knew it was going to work, he announced to everybody, I'm going to quit, and he did. And he also told Mrs. Wilcox, get rid of the ashtrays, throw my cigarettes out now. He told her, before he even knew the patch was going to work, that she needed to throw his cigarettes out and stop buying more. So the evidence will be that Mr. Wilcox did not make a serious effort to quit before 1992. And why is that important? Because you've heard about plaintiff's admission of fault in this case, and that they've admitted that Mr. Wilcox did not try hard enough to quit, and he did not try long enough to quit. And the evidence is going to show that the one time he did try hard enough or long enough was 1992, and it worked for him. Unfortunately, he had a very dramatic experience with the Hurricane Andrew in his home. But when he did try hard enough and long enough, he quit. And that shows, their admission shows, and his action shows that Mr. Wilcox could have quit permanently anytime he wanted to if he had tried longer and harder beforehand. Now, I want to turn back to the claim in this case related to plaintiff's burden.
Your Honor, silence as an admission. Begin.
Sustained.
Okay. You heard Mr. Gustafson talk about this campaign of doubt and how the tobacco companies were trying to confuse smokers and tell smokers, you don't need to quit, smoking's not bad. There will be no evidence that Mr. Wilcox was exposed or heard or believed any of the campaign of doubt, or that it even reached him. In fact, the evidence will be just the contrary. The evidence in this case will show that he always knew that smoking was dangerous and addictive, and he chose to continue to smoke anyway. And if you look at their claims for concealment and agreement to conceal, remember the chain that we've already looked at. And I told you they're going to have to link up. They have to link the Engel findings to Mr. Wilcox's death. And they can't make the links connect because Mr. Wilcox knew the dangers of smoking. And you can't conceal something that somebody already knows. You can't cause somebody's death because you conceal something if they know it. That's common sense. Now, the evidence will prove that they can't provide the links and their claim fails. And you may say, why? Well, we've been through it ad nauseum. I'm just going to throw this up and quickly go through it again because there were warnings Mr. Wilcox received throughout his lifetime. From his family, his wife, from his doctors, from his schools, newspapers, cigarette packs, the Surgeon General, and the public health community. He was receiving warnings about cigarette smoking, and he received not only just general warnings that were out there in the public, he received personalized warnings from his doctors and his wife in 1974. And you heard a lot about these organizations called TI, the Tobacco Institute, CTR, the Tobacco Industry Research Committee that Mr. Gustafson talked about. But there will be no evidence in this case that Mr. Wilcox even heard of those, much less heard any of those statements that he showed you in his opening statement. There'll be no evidence that he heard anything CTR said or TI. And there'll be no evidence that he even saw an advertisement from my client, R.J. Reynolds Tobacco Company. No evidence at all about that. Now, I want to talk briefly again about lights and filtered cigarettes, because as Mr. Gustafson told you, before we come in here, we can take depositions, and we can only assume that their witnesses will appear to testify in court, and they have a witness named Dr. Strauss. And Dr. Strauss is from Boston, and we talked to him. He's an epidemiologist, lung cancer doctor, and we talked to him about filtered and light cigarettes. And this was his testimony. No tobacco company ever said filtered or light cigarettes were safe or safer. That's his testimony. He said that if Mr. Wilcox heard that filtered and light cigarettes were safer, he heard it from the public health community. Through those PSAs I showed you, where the public health community was telling smokers to quit or to switch. He also told us that the public health community based this recommendation on a scientific consensus that light cigarettes were safer. That's the epidemiology I told you that they had that showed that light cigarettes were safer. And he said that scientific studies since the 1970s show that light cigarettes are safer in terms of lung cancer risk. So Dr. Strauss will tell you that Mr. Wilcox didn't switch to light or filtered cigarettes because of anything R.J. Reynolds Tobacco Company did or said. It's because of the public health community encouraging smokers to quit. And if they didn't quit, they should smoke light cigarettes. Now, I'm going to end where I started and put up the 5 fundamental facts, that all the facts you need to know to answer your verdict in this case. If I can find them. Sorry, Nancy. And again, the evidence in this case will show these 5 facts, and these 5 facts are all you need to answer the verdict form that you'll get at the end of the case. Mr. Wilcox did not...
Again, objection, silence has an admission at the end.
Overruled.
Mr. Wilcox did not start or continue smoking because of anything R.J. Reynolds Tobacco Company said or did. Mr. Wilcox understood the dangers of smoking for decades and never questioned the risks. Mr. Wilcox did not make a serious effort to quit until 1992, when he was able to quit on the first day he tried. And plaintiff cannot prove that Mr. Wilcox died from primary lung cancer caused by smoking. And plaintiff admits that Mr. Wilcox was a legal cause of his own death. And those 5 facts are the facts that you need to know. And I'll just remind you of the words of the witnesses in this case. Mind your own business. Don't ever question me again. He did what he wanted to do. Things were done his way. He didn't want to have anybody tell him he shouldn't smoke. I want to thank you. I know it's hard because I always get to talk with you guys after lunch, and it's when everybody's sleepy and tired of listening. So I appreciate your attention not only last week because you were very attentive during voir dire, but also today and throughout this case. Thank you very much.
All right. Thank you, Ms. Henninger. Ladies and gentlemen, we're going to take a short break right now. If you all could please leave your notepads face down on your chair. And exit out with Victor. And Victor, please have everyone ready to come back in at the door at 3:30.
All rise.
everyone can take a seat, we will take a short break. You all can look at the documents that you are going to be putting on this afternoon. And you indicated there are sufficient amount of documents that are not objected to. Is that?
I believe and hope. I'll discuss it with Mr. Green.
Okay. All right. I will see you all back just before 3:30.
Thank you, Ernest.
issues.
Well, Your Honor, we received from the plaintiff yesterday approximately 500 exhibits that they disclosed to you today. We went through those and do what we generally do in these trials, which is to prepare a notice of filing objection to the exhibits, the written objections, if I may hand them up.
Okay.
What we do is we recognize that there are many documents that we object to and that we maintain our objections to that almost always come in. And there are some of those documents that Mr. Sales has indicated he'd like to publish this afternoon that we object to, but we're willing to stand on our written objections. And that's what we're on. Just after.
All right, Mr. Sales?
One thing, so that the court understands the volume and that the court is not misled, and I don't mean intentionally, about the numbers. For example, we will display, if I don't think they're going to object to this, a composite of magazine ads. Each one of those has a unique identification number. So on this one page, there's probably 60, 40 maybe, so that you understands the volume. It's not going to be like this with respect to all the documents. I have two questions for the court. I'm asking sort of for an advisory opinion. I don't know if it will assist the court because we take some time to compile where all these documents that we're going to be talking about have been admitted so that Your Honor can get a sense of what other Your Honor's colleagues have done. Would that be helpful to the court?
Go ahead and pass that up. How long will you all need, once we're done, to publish these to the
I
jury?
have more than I could probably read until we finish today.
So you want to read them and then pass them around?
We're not going to have to, everything that the excerpts that we want to highlight for the jury, similar to what was done in opening statement, once they're admitted, if they're admitted, we would just read highlighted, selected portions.
Okay.
And to be clear, I mean, Mr. Sales gave me a list at lunch of documents he'd like to publish. There are approximately two-thirds of those we would rest on our written objections. Approximately 10 to 12 or 15 of those we would ask for oral argument, perhaps after they publish them.
Well,
okay.
But I put them in an order on purpose so that we can try and put on a case that makes sense. So my question that I was getting to for the court is, would Your Honor like to hear arguments on those now, or should we do the ones that would be sort of out of order from my point of view? It doesn't matter that much to me.
Let's go in order with the first objection, and we'll see how far we get.
Thank you, Your Honor. Your Honor, are you able to display these? I think that would be good.
I have hard copies.
I have a hard copy set for the court, but I think so we can all see what we're looking at.
All right, go ahead.
The first one, I've marked all the ones you object to. The first one that they object to, Your Honor, are the two letters that have been discussed and shown in opening statements, or one was, that are the marketing letters to R.J. Reynolds' staff. In the beginning, they are 4013 and 4014. They're slightly different, but I assume the objections are the same to both.
All right. Are these the ones that you'd like to have oral argument on?
Yes, sir.
Okay.
And the reason we're asking for oral argument, I understand the court's ruling pre-trial that documents that the plaintiff uses to suggest that Reynolds and other companies engaged in youth marketing during the time period that Mr. Wilcox was a youth might be admissible. These two documents, Your Honor, are so highly prejudicial that we would ask that the court, even under prior ruling, still exclude them. If Mr. Phillipson would please blow up the first paragraph. It's a document from 1928 from the R.J. Reynolds Tobacco Company in Winston-Salem. Important about this document is it talks, what it does not say is that any of these activities were undertaken in a place where Mr. Wilcox. So the probative value is very high. The prejudicial effect of this is obviously very high. And on the 402, 403, and 404 basis, we'd ask the court to exclude this document.
Okay, from the plaintiff?
In these cases, Your Honor, no one can put much in the hands of the smoker. We just heard, and we're not going to object, to a century's worth of Reader's Digest articles, none of which can be put in the hands of the dead smoker. That's not what this is about. What this is about is to show that Mr. Wilcox grew up in a culture where it was not only not unusual for school-aged people to be smoking, but this is something that was encouraged and solicited by the company.
They don't dispute that. They just say it's really bad. But you just heard an opening statement where they say, at age 8, we should have known better. They showed you the school books, an opening statement from the exact same era.
I understand the arguments. This document is admitted.
The next one, it's 4014, is similar. I assume the objections are the same.
The objections to the next document is exactly the same.
All right, this is dated September 9th, 1927.
Yes, Your Honor, I'm sorry. For the record, it's PT 4014. The content is similar, slightly different, but similar. And those are the only two in that series.
All right, and he was born in 1924?
Yes, Your Honor.
This document is admitted.
The next document, Your Honor, is PT 3400. That was the other document that we discussed at the hearing, which I talked to Your Honor about. Mr. Gustafson talked about it. It is the 50-year retrospective review in 1984 by a vice president at R.J. Reynolds discussing these very matters and explaining that 16.7 is the median age for smoking, and the explanation of brand loyalty and success of every brand during that period of time is due to the attraction of smokers to youth, and that actually covers nicely the initiation date for smoking for Mr. Wilcox, because 82 minus 50 is 34, 2 years after he would have started smoking according to the medical records that we have.
Defense?
Your Honor, this is a 1984 document. I do not dispute that this was discussed at pre-trial hearing, and that there are portions of this that are retrospective and look back into the 1930s, perhaps in the early 1940s when Mr. Wilcox was youth. But as I mentioned, it's a 100-page document, and there are substantial portions of this that go far beyond that and look at what plaintiff's experts will say was youth marketing in the 1950s, the 1960s, 70s, and 80s. And they'll also say that it contains, as you can see in the first paragraph, that it's going to be a plan for the future, talking about from 1984. So there are portions of this that fall both within and outside of the court's ruling on the youth marketing evidence. And we think it should be redacted accordingly, that only portions of it that would be retrospective back to when Mr. Wilcox was youth should be admitted.
Your Honor,
on that?
Yes, Your Honor. That's never been done in any case that I'm aware of. Your Honor has the schedule. You can see how many times this document is admitted, as I previously told the court, and I say everywhere I go. To me, having done this for 10 years, this is the most important document in the case because it explains why people smoke, when they start smoking, what appeals to them. And I understand what counsel said, Your Honor, but I think it's important to remember this. Their position in the case is that he should have never started smoking. This document analyzes why people over 50 years smoke at various ages. Yes, from 14 to 24, but it is an affirmation of the plaintiff's theory of the case, and it is an admission of a party opponent as to why this man started smoking.
What was the date the document was released?
84. It was never released until it was the subject of a lawsuit and disgorged. But it was circulated internally. Secret is the label on it in 1984.
All right, this document comes in.
And the next one that I have about which there's a dispute is a document from, it's PT 3289. It is from 1958, which would I point out to Your Honor, sometimes this objection, hearsay, exception to the hearsay rule does not come up very often, but documents that are over 20 years of age are deemed non-hearsay if the content of them is not hearsay. This is a document, the authenticity of which I don't think is going to be disputed. It is a document of British American tobacco scientists who came to America to find out from
Counsel, since they're moving to exclude it, let me hear from them first as to why.
I think that the predicate that we haven't heard is that the British American Tobacco Company was not an Engle defendant. It's not a defendant. In this case, it's not a co-conspirator under Engle. Instead, it's a separate company that's based in England. So, therefore, the Engle findings that relate to conspiracy, co-conspirator liability, do not apply to this company. This company was the author of this document.
How is it relevant here, Mr. Sales?
as I was trying to explain that, Your Honor, it contains statements by American Tobacco Company officials, that is them, officials of the TIRC, that is their co-conspirator, its predecessor, later called the CTR, and other officials within the industry that were members of the conspiracy specifically. Those are admissions of party opponents. The objection to it is that it's authored by people who recorded the admissions of party opponents and their co-conspirators. However, as I pointed out, Your Honor, I would recite to the court the ancient document exception to the hearsay rule, that is 803.16, and what it tells us, which they're going to offer documents based on the same exception, I will report to the court, I don't think counsel will dispute it, is that statements in a document in existence 20 years or more, the authenticity of which is established. That is an exception to the hearsay rule. It's only accepted from the exception if the content of if the content of the information would itself otherwise be inadmissible. But when officials of American Tobacco, the TIRC, and other co-conspirators said in 1958, we believe cigarettes cause cancer, which is what they said when they were interviewed, that is not something that would be excluded under the hearsay rule if they had made the statement themselves. So I think Your Honor has the table there. You can look at the PT number on the schedule, 3289. I don't know what we're up to in terms of the number of times that the document has been admitted, but you can see it's a couple dozen cases at least. I don't think it's ever been excluded in any of our cases. Never.
This is in the list you gave me.
Yeah, 3289. Yes, Your Honor.
Okay, I have it. All right, any rebuttal from defense on that argument? These are statements of individuals who worked at your client's company for your client.
Some of the statements are contained in the document from the client. The court looked at there are a number of individuals from all sorts of areas that attended these conferences, including from the Medical College of Virginia, Duke University, etc. I'm not precisely sure what portion of the document they want to use because it is rather lengthy.
The same portion we always use.
The highlighted in yellow on the screen.
Could you show the content? It's a statement later in the document where it says, we interviewed all these people, and every one of them, except a professor at Yale, says cigarettes cause cancer. His name was Green. It's the same statement we use in every case. And so that would include all of the people that were interviewed. Yes, it would include others for whom there ought not be value to any objection, but it included the people that are identified that are their co-conspirators.
All right.
Therein lies the problem. We're talking about interviewing other people who are not focused.
Can I see the exact language of what you want to use?
Go back to it. Okay. And this is after they interviewed all those people on the schedule. With the one exception, HSN Green, he was a professor at Yale. The individuals whom we met, that's every one of their co-conspirators, believe that smoking causes lung cancer, if by causation, and that it explains what they mean.
Okay.
The problem is it lists approximately 30 people, many of whom are not even related to the company, people who are identified as co-conspirators.
All right, that goes to weight, not admissibility. It's admitted.
The next one, Your Honor, is PT 3615, Hippo Patel.
Okay.
The objection to this document depends upon which portion of the intent is displayed to the jury. Perhaps they should give us some guidance on that.
The same portions that were shown in opening statement. That we know that nicotine is an addictive drug. We expect the Surgeon General to say that cigarettes cause lung cancer. So when he does that, we're going to tell the public, here's a new triple, quadruple, quintuple filter. The same portion we always use.
Your Honor, based on the representation that this is the only portion they intend to display to the jury, I'm willing to stand on my written objections to this document.
All right, the objection is overruled. Next document.
The next one is 1933.
The January 29th, 1964 memo.
This is a statement by an executive at Philip Morris, a co-conspirator. It's important to note, Your Honor, that the recipient, is it from Coleman too? It's from Weissman, who was a senior executive at Philip Morris. Philip Morris was monitoring the release of the Surgeon General's report. Immediately after it came out, he reported to the chief executive of Philip Morris, who happened to be on the executive committee of the Tobacco Institute at the time, that what we got to do now is give people a psychological crutch for continued smoking. And the story that will be told through the witness tomorrow, in part, will save some time once this is in, if we get it in now, is that that's exactly what they did for the next 30 years.
There are portions of this document on other pages which implicate some of the court's pretrial rulings. If they're not going to publish those portions, then I'm going to stand on my written objections to this document as well.
I think for now we're okay.
All right, so then just as portion, the objections are overruled.
And perhaps, Your Honor, when these documents are prepared to go back to the jury, we can raise those portions and have them redacted.
If the court agrees when we argue those later, because I think those may melt away, as you'll see later, Your Honor. But we won't publish those portions now.
All right. Any others?
Yes, you see one that takes too long. The next one, Your Honor, is another Tobacco Institute memo. It's May 1, 1972. The Roper proposal shown in opening statement, PT 2050.
Our objections to this document, Your Honor, are limited to the last two paragraphs of this page, which we would ask to be redacted from the document. Number one, on the portion of the document which talks about on the litigation front. We object to that because, number one, our litigation strategies are not on trial here. We cannot be liable for defending ourselves in court, and that is from the United States Supreme Court Williams case, from a number of third and fourth PCA cases, which all say the defendants have the right to defend themselves in court. So we would object to that paragraph on that grounds. The next paragraph discusses on the political front what the industry is doing with respect to advocacy, lobbying, petitioning activities of Your Honor calls in order to put that type of evidence in front of the jury. The plaintiff has to make a showing that whatever was said to Congress or a government agency or government official was a false statement. That was the ruling we had last week during jury selection.
All right. Mr. Sales?
I made 3 notes, very few others, in Ms. Henninger's opening. One of them was to point out to the jury the date of the first, implying there were others, lawsuits filed against the industry. I think the important thing, so I think that should go by the wayside. But more importantly, Your Honor, as we explained in the pretrial hearings, this document 42 years ago doesn't put these lawyers in the defense of this case on trial. What it does is educate the jury that one of the reasons that the companies conspired to lie to the public was to win lawsuits, just like the one that Ms. Henninger was talking about in opening statement. I don't know why, if they're raising the objection that lawsuits outside this courtroom are out of bounds, that they mention those in opening statements. I don't agree. I agree that it's relevant. I agree that it's part of the public information that there were lawsuits. But most importantly, the head of the Tobacco Institute, which is a named co-conspirator and a defendant in the Engel case, senior executives, the 2 most at the time, explain why it was that they did the thing that puts us here in court. And that cannot, most respectfully, be excluded from the discussion of why it is that they were doing what they were doing. On the issue, sorry.
You're going to lay a foundation as to this when you get to that portion of the case, or is it just through this document?
Absolutely. Our witness will talk about that, and if Your Honor would prefer that we table this one until Dr. Proctor explains the context. No problem. And respectfully, Your Honor, if when we're doing this and reading them, if I come to one and I'm not doing what, I'm not making notes right now. Can somebody just please help me, not make a mistake, okay?
Now, one thing I'd like to get clarity on, I understand that the documents we're going through the public and we would object to having them again public when Dr. Proctor's on the stand as duplicative and unnecessary.
Obviously, we're not going to waste the jury's time like that.
Okay. Any others?
The next one is 2268.
Regarding the November 17th, 1978 meeting in New York.
Yes, Your Honor. This is a document. The counsel, CTR, which is at the top. Art Barron, can you show at the very top? CTR is an Engle defendant and one of the co-conspirators. This is an explanation of what it is, and it describes the parties who participated. One of the things that Your Honor is going to learn is that the lawyers for some of these companies, their in-house lawyers and outside lawyers, ran all of this. And so they're identified there. But the purpose of this is to show what it was. There was a suggestion in opening, sort of dueling suggestions about the validity of the science. What this document helps lay a predicate for is the industry's actual support. Mr. Gustafson called it, and I think Your Honor will see it's supported by the evidence, fake science. And this document speaks to that.
Your Honor, this is a document that reflects a meeting between lawyers and their clients. On the second page, the document, throughout the document, talks about lawsuit and litigation. On the second page, it says CTR has helped. The second highlight: CTR has helped our legal counsel by giving advice and technical information which was needed at court trials. CTR has supplied spokesmen for the industry at congressional hearings. The money spent at CTR provides a base for introduction of witnesses. There's a lot in that paragraph and others to unpack. Point being, number one, that CTR was assisting the industry at congressional hearings. That is privileged, cannot be liable for that. There's been no allegation that whatever this document is referencing was false or misleading and fraudulent. That's point number one. Point number two, whether CTR helped legal counsel give advice and technical information in court proceedings is irrelevant. It cannot support liability. There's case after case after case after case in Florida and by the United States Supreme Court that says you have a privilege to defend yourself in court, and you cannot be liable for it. This document is all about the defendant's litigation of court proceedings. In addition, it has some of the petitioning efforts to Congress as well. That is privileged information. There's nothing wrong with it. You can't be liable for it. It should be inadmissible.
How is it not privileged?
I guess we're not looking at the same document, counsel and I, because it's a document about CTR, an Engle co-conspirator, which is a defendant in the case, for whom this defendant is liable if the jury believes that that had an influence on the smoker's smoking behavior that hurt him. And it talks, and it's underlined there.
So this goes to your conspiracy theory?
Yes, it says that it was set up.
This document is admitted.
Thank you, Judge. I have a few more that there are objections to. May I speak to counsel for a minute? I'll speak. That's one of the ones you gave me as a number. Speech by Horace Corrigan.
Just one page?
It's 2 pages. 3, 4, 5. You're the one who objected to it. Did you tell me what the objection was?
All right, the next one is PT03777. This is a document from the Tobacco Institute annual meeting in 1980.
Okay.
Throughout the document, there are references to the TIRC's efforts in opening discussions with governmental agencies, such as the HEW got in contact with President Carter contact with certain members of Congress. It discusses efforts in lobbying and petitioning on page 3 with respect to a Dade County ordinance on an anti-smoking referendum.
All we want is on page 2. It says that they...
Which portion do you want to admit?
The Surgeon General's media event was preempted by an institute's First Strike news conference. For the first time in the history of the cigarette controversy, the Secretary of HEW had to share the spotlight. In fact, we won top billing that night on all networks.
Your Honor, we'd be willing if they would simply redact the rest of the document.
This is the only thing, correct, counsel?
No, there's more. Talks about the power. You heard Ms. Henniger say that nobody was listening to the tobacco industry. They were only listening to public health officials. This says the opposite, an admission by a party opponent. Talks about how many people that they reach with their newsletter that says bald men get cancer more than people with hair, that kind of thing.
Again, Your Honor, we redact the portions of the document.
That's not the last one.
Privileged information.
Before I hear from defense, can you show all the portions you'd like to admit?
This is a portion that's privileged.
How is that privileged?
It's privileged because the defendants are entitled, they're privileged to have contacts and communications and influence with government officials, including, in particularly, members of the United States Congress. There is nothing wrong with this. You cannot be held liable for having grade A contacts with Congress. That is not an actionable. Piece of conduct.
Okay, everything up until this point comes in. As to this issue with having contacts, what does that go to prove?
It goes to prove the same thing that Ms. Henniger was talking about in opening statements about what was happening in the public domain. This is a suggestion. This case is being tried as in every other case about what was out there. What did people hear? What did they know? And what people were doing or saying everywhere. Ms. Henniger talked in opening statements about people who appeared before Congress to express their view, as she explained it, that the defendants were all wrong, that cigarettes cause cancer, implying that everybody should have known better. And we're not seeking to impose liability for the contact with Congress. What we're seeking to show is that there were two sides to this story, and this is a fair explanation of how it is that that happened. Nobody will ask the jury to impose liability, but how can the defense get to tell the jury what they were doing, the favorable parts, what comes out of Congress when they want to show it to the jury, but we can't show what the other side is? I would submit to Your Honor that no lawyer for the plaintiff will suggest ever that the defendant should be held liable for fairly and honestly dealing with Congress. And this doesn't speak to that one way or the other. It just says we're there, giving our point of view. Just as when the guy ran down the steps in the video that was shown by the plaintiff, as Your Honor will hear from the evidence, actually, what you'll hear from Dr. Proctor is they were paying people. CTR was paying people to go over there and try and tell congressmen and other people things that are lies. That's not protected by any federal doctrine.
Okay. Anything else?
There's no allegation for this paragraph that anything covered here is fraudulent or false. This is simply trying to impose liability for having contacts with Congress. That is what's privileged. And it violates Your Honor's pretrial ruling on precisely this topic.
No.
Okay. I don't think this last paragraph is relevant, subject to whatever foundation you might lay on it.
All right, Your Honor.
Any other documents?
There are two others over which there are objections.
Okay.
One is 2184. Oh, there was one more on that one. I'm sorry. That doesn't seem harmful.
We're willing to stand on our objections with respect to that portion. Thank you.
All right, so you got the second to last ones out, okay, for now. Got it? All right, thank you. 2184, Your Honor, has heard about this. It was shown also in opening statement. This is we call it the NOPIC to Clofer, K-N-O-P-I-C-K, K-L-O-E-P-F-E-R, both executives at the Tobacco Institute.
It's 2184?
Yes, Your Honor.
And the portion of this document that we object to is the very last sentence in the document.
All right.
Which says that
Mr. Sales, what issue is that relevant to?
It's an admission of a party opponent, co-conspirator, the Tobacco Institute, that says it is incompatible to contrast choice with addiction. And the backstory of this is very important, Your Honor. It's cited in the first part that we haven't looked at. It says that there's a developing idea that nicotine is addictive. As late as 1980, despite what we've just heard in opening statements from the defense, that nicotine is addictive, and that the National Institute of Drug Abuse was thinking of saying so. And the tobacco officials institute officials are talking about how they were asleep at the switch about that, and what are they going to do? And woe is me, what they say is, if that gets out, we have a major problem, because we can't call it choice if there is addiction. And that's the plaintiff's case versus the defendant's case. The fact that they're relating it to lawsuits is relevant, as I would submit, Your Honor, was argued previously, because one of the legs of the stool of the conspiracy, as is revealed in the 1972 Roper proposal, is to win lawsuits. And apparently, Your Honor, on our schedule that was not omitted. But I would like...
I do not see it.
Yeah, but I mean, just, if you would, Your Honor, take a look. I know we're not supposed to use the word weight of authority literally in these proceedings, but that is a cornerstone document in these cases.
And the reason it was offered for its admission is precisely why it should not be admitted. It was suggested that the fact that this is relevant to establish that Reynolds could not assert a defense in a lawsuit is the reason why it should be admitted is facetious. It's incredible, because Reynolds has a right to defend itself in litigation, and this document simply says that the matter of addiction might undermine one of our legal defenses. Mr. Sales said that the litigation fund is one of the cornerstones, the pillars of the conspiracy. There's no Engle finding on that. There's no established, and Mr. Sales is laughing, unfortunately, but there's no established element that the defendants, the tobacco defendants, engaged in a conspiracy to conceal information to further themselves in litigation. That's their allegation, but that's not something that's established in Engle cases. This document only goes to Reynolds' defense of itself in litigation, which it is entitled to do. This portion of the document does. And since it's entitled to defend itself in litigation, this is privileged. Reynolds cannot be liable for that. We would ask that this portion of the document be redacted.
May I be heard briefly, Your Honor?
Yes. Okay. Shook Hardy is their outside counsel, correct?
Not them. We have another version of this where we substitute the lawyers, which they said they don't care about that because they're not. Shook Hardy's not here. But just the Shook Hardy, I don't think is a hang-up, right?
It should say Shook Hardy.
Okay. Because they're not here. If they were here, they'd say take it up. But what I was going to say, Your Honor, is it is lawsuit 101 to contrast what people say when meeting privately and what they say publicly. Not these lawyers, but publicly, the Tobacco Institute, and as Your Honor knows, until 1994, the chief executive officer of this defendant said the opposite of that. He said it's not true. He said it under oath. And here you have an emerging consensus in 1980, which Your Honor will learn, would have saved millions of lives if there had been a consensus about the addictiveness of nicotine, because that's when nicotine therapy started to be developed. And here it is that they're saying, we can't let people say it. We can't even breathe the word addiction, because if we do, we are thereby acknowledging that people do not simply choose to smoke, that it is in fact an addictive drug. That is the point of this. It's not an attack on counsel or the defense in this case, but it is certainly fair game to contrast the position that a lawyer takes that nicotine is purely a matter of choice when their co-conspirator says, no, it's not. And that's what this reveals.
And who's saying this?
Two executives, one to the other, of the Tobacco Institute, and Engle, defendant.
Okay, I think this comes in.
So leave it, Shook Hardy.
Any others?
We're not going to get past that part of it.
Okay. All right. We'll go ahead and do these documents, and then after the jury leaves, we'll talk about scheduling. Can everybody start at 8 tomorrow? Does anyone? I don't know how far you all are driving in terms of getting here in the mornings.
We're all here.
We're living here, so. We're living around the corner.
Okay.
Just for the record, the documents that the plaintiff intends to show apparently, that we are going to stand on our objections, I just wanted to list what those were.
Go ahead.
They have a record of that.
Yes.
Those are they're all PT0 numbers. They're PT01044, PT01553, PT01608, PT02061, PT03695, 3694, PT02602, 2044, 4791, 1809, 3709, 3681, 2817, 1552, 3569, 2278, 1820, just a couple more, 307, 2130, 1941, 2538, 2510, 1941, and 9041, and we'll stand on our written objections for those documents.
Okay, so we'll go ahead and bring in the jury. Mr. Sales, you will start after we finish with these documents. I'll discharge them to come back at 8 o'clock tomorrow, and then I'll talk with you all about which witnesses are lined up and kind of scheduling for the rest of the week. All right?
Are we taking a short break? Can we have?
Yes, if you want to take 5 minutes before we start that, we can do that. So we're adjourned for 5 minutes.
All right.
and ready to start?
Yes, Judge.
Okay, Victor, please bring our jury back in.
All rise for the jury.
Welcome back, ladies and gentlemen. Everyone take a seat. Thank you for your attentiveness and cooperation and patience. We'll now turn this over to Mr. Sales for the plaintiff to begin their case.
Thank you. Good afternoon, everyone. Your Honor, at this time, consistent with the court's rulings, the plaintiff would move into evidence and seek to publish portions of select documents offered in the plaintiff's case in chief, beginning with PT 4013, a letter from R.J. Reynolds Tobacco Company dated June 13, 1928.
All right. All of the documents that we've gone over are admitted.
And, Your Honor, I won't ask every time, but once Your Honor rules, may I publish portions of the documents?
Yes. Would you like the instruction on
yes,
evidence? Okay, the document you're about to see has now been received in evidence. Witnesses may testify about or refer to this or any other item of evidence during the remainder of the trial. This and all other items received in evidence will be available to you for examination during your deliberations at the end of the trial.
Thank you, Your Honor. Baron, would you put up PT 4013? And again, members of the jury, and Your Honor, this is a letter dated June 13, 1928. Regular school is over. Summer school is starting. Most all high schools, prep schools, colleges, and universities have finished the spring term, and summer schools are now getting underway. This means that thousands of special students and teachers, both men and women, will be assembled at various places during the summer months. Go ahead, if you would, Baron. At any rate, we want you and your men to give these schools immediate attention and then follow up from time to time as often as possible. Moving down, please get started in this work at once. Get your men intensely interested in lining up these students for our brands, both as consumers and boosters. And see to it that the stores and stands near the schools have a good supply of our product. Concludes the reading of that one, Your Honor, and the plaintiff moves in at this time PT 4014, another letter from the defendant dated September 9, 1927.
Okay.
Go ahead, Baron. School days are here, and that means big tobacco business for somebody. Let's get it and start after it right now. Give every school a good working just as quick as possible after it opens, doing trade building work in accordance with present plans and policies. Line up the leaders and the most popular students. In other words, get off to a good start just as quick as you can, and then keep up this work at regular intervals. I believe that concludes that document. Your Honor, the plaintiff would move at this time into evidence PT 3400, a strategic research report of Diane Burroughs from R.J. Reynolds Tobacco Company dated February 29, 1984.
Okay.
Members of the jury, Your Honor, this is a strategic research report previously labeled secret from R.J. Reynolds Tobacco Company, addressed to Mr. Long, Mr. Orlowski, and Mr. Lees from Diane Burroughs, and captioned Younger Adult Smokers, Strategies and Opportunities. And Your Honor, members of the jury, we have a few sections of that document to read. Go, if you would, please, to the first one. It says Management Summary. The importance of younger adult smokers. Younger adult smokers have been the critical factor in the growth and decline of every major brand and company over the last 50 years. They will continue to be just as important to brands/companies in the future for two simple reasons. The renewal of the market stems almost entirely from 18-year-old smokers. No more than 5% of smokers start after age 24. The brand loyalty of 18-year-old smokers far outweighs any tendency to switch with age. I'd like you to go to Appendix B now before we go through the rest of it, which is at the end. Members of the jury, Your Honor. There's a page of the document, if you could catch the upper right-hand corner there, Baron. It's titled Appendix B. Younger adult smokers' importance as replacement smokers. And then there's a graph and a table below. Let's show the graph first with the label. Can you catch the headline above that? So there's an age axis on the bottom, and it runs from age 13, all the way to age 24, and there's a percentage, and that's explained at the top. It's referring to the percentage of starting age. In other words, the number of people by that age who had started. Go, if you would, please, to the bottom. There's a table. Current male smokers by starting age. Gives the started ages ranging from 12 to 25 plus, and a median age for the start age of male smokers, which is listed as 16.7 years. All right. If you would go back to the beginning of the document then, Baron. And it talks about younger adult smokers. Why then are younger adult smokers important to RJR? Younger adult smokers are the only source of replacement smokers. Less than 1/3, 31% of smokers, start after age 18. Only 5% of smokers start after age 24. If younger adults turn away from smoking, the industry must decline, just as a population which does not give birth will eventually dwindle. A few more excerpts from that, Your Honor, members of the jury. In Section 2, there's a discussion of successful first brand strategies of the past. This section traces every brand which has risen to a 10% or higher share among 18-year-old smokers since the 1930s. There have only been 6, but they include the major brands of the last half-century: Pall Mall, Winston, Marlboro, Kool, Salem, and Newport. Go ahead. And then there is a discussion of Salem, just showing this portion for now: Salem, Kool, and Newport. Salem's product breakthrough was light menthol. When Salem lowered the menthol and added a filter, it cut an 8% niche in the market. I think there's a couple more on that. That was the last one. Thank you, Your Honor. That concludes 3400. The next document that we have is Claude E. Teague Jr.'s Survey of Cancer Research, dated February 2, 1953. It's PT 3608. Your Honor, we did not discuss this one, but I think counsel is resting on the papers previously supplied and has no further objections.
Correct.
You may proceed.
Thank you, Your Honor. We're moving this in then at this time.
Okay.
This is Survey of Cancer Research with an emphasis on possible carcinogens from tobacco from Claude E.T., 1953, February 1953. Karen, if you would, please go to page 5, the last full paragraph. Several statistical studies based on clinical data on cancer of the respiratory system have been made, and these studies indicate an abnormal increase in the incidence of such cancers, particularly among men, during the last several decades. These studies indicate that some carcinogen, either airborne or artificially introduced into the respiratory system, is responsible for cancer of the respiratory system, and that widespread exposure to the carcinogen, particularly among men, has been fairly recent and is increasing. The recent rate of increase of cancer of the respiratory system rather closely parallels the recent introduction and rate of increase of cigarette consumption, and this, together with the fact that until very recently the vast majority of cigarette smokers have been men, has raised a very considerable question. There appears to be a growing suspicion, or even acceptance, among medical men and cancer researchers that the parallel increase in cigarette consumption and incidence of cancer of the respiratory system is more than coincidence. Go, if you would, please, to page number 10. There is rather general agreement that the incidence of cancer of the respiratory system has increased greatly in the last half century. Moving down to where the 26 is, a few lines down, whereas cancer of the lung was a rare disease 25 years ago, it now occurs nearly as often as cancer of the stomach and more often than cancer of the colon. Moving down to the next paragraph. The increase in the incidence of cancer of the lung, which has occurred in the present century, suggests new or increased contact with carcinogenic stimuli, such stimuli being either airborne or artificially introduced into the lungs. The suggestion that smoking, in particular cigarette smoking, may be a causative factor in the induction of cancer of the respiratory system, including the oral cavity, has been made by many writers on the subject. In 1941, Ochsner and DeBakey called attention to the similarity of the curve of increased sales of cigarettes in this country and the greater prevalence of primary cancer of the lung. Go, if you would, please, to the next page. To the numbered points 1 through 8. Excessive and prolonged use of tobacco, especially cigarettes, seems to be an important factor in the induction of lung cancer. That's 1. 2, the incidence of lung cancer is considerably higher among moderately heavy to chain smokers compared to the general hospital population without cancer. 3, the occurrence of lung cancer in a male non-smoker is a rare phenomenon. Number 5, 96.1% of patients with cancer of the lungs who had a history of smoking had smoked for over 20 years. Few women have smoked that long, and this is probably the reason for the greater present incidence among men. 6. 94.1% of the male patients with cancer of the lungs were found to be cigarette smokers, 4% pipe smokers, and 3.5% cigar smokers. 8. 3 independent studies have resulted in data so uniform that one may deduce the same conclusions from them. Go to the conclusions at page 14. Conclusions. The increased incidence of cancer of the lung in man, which has occurred during the last half-century, is probably due to new or increased contact with carcinogenic stimuli. The closely parallel increase in cigarette smoking has led to the suspicion that tobacco smoking is an important etiologic factor in the induction of primary cancer of the lung. Studies of clinical data tend to confirm the relationship between heavy and prolonged tobacco smoking and incidence of cancer of the lung. Your Honor, that concludes the reading of PT 3608. The next document we have, Your Honor, is PT 1044.
Okay.
Which is a telegram from Paul Hahn, President of the American Tobacco Company, 111 Fifth Avenue, New York, New York, to E.A. Dar, President of R.J. Reynolds Tobacco Company in Winston-Salem. Would you go a little bit higher than you have first line there in view of? In view of the highly publicized claims of certain medical men not sponsored by any duly accredited scientific medical organization charging serious danger to health from smoking, I suggest for your consideration a meeting of the heads of all of those cigarette companies that have manifested active interest in scientific research and are therefore informed as to the true facts. So if you would please down. Where you have highlighted. Where you have highlighted. And it indicates that the telegram was addressed to the presidents of R.J. Reynolds, Liggett, and Myers, Lorillard, Philip Morris, Brown and Williamson, Benson and Hedges, and Mr. Hudson as representative of tobacco growers. That concludes the reading of that document, Your Honor. The next one is PT 2016, the forwarding memorandum from Ed, I always say his name wrong, Deacons, forwarding memorandum from Hill and Knowlton. Yes, sir. This is from the files of Hill and Knowlton, and it says that this is the members of the planning committee. Go, if you would, please, to the first highlighted section. The attitude of the men we must directly deal with in the industry is at once interesting and important for us to understand. That is why notes on the 4 interviews with research directors are given at some length. You'll get little from them, you'll get from them little real information about lung cancer, pro or con, but you'll find some mighty interesting opinions. One of the men said, "It's fortunate for us that cigarettes are a habit they can't break." Said another, "Boy, wouldn't it be wonderful if our company was the first to produce a cancer-free cigarette, what we could do to competition." Said another, "Suppose everybody smoked just 1 cigarette a day, that would be maybe $40 billion a year. And again, the stock market fall is terrible when you remember dividends are going to be much larger next year without the EPT.
So if you would please, the next highlighted section.
There is only one problem: confidence and how to establish it, public assurance and how to create it, in a perhaps long interim when scientific doubts must remain, and most important, how to free millions of Americans from the guilty fear that is going to arise deep in their biological depths, regardless of any poo-pooing logic, every time they light a cigarette. Sorry? Next paragraph, yes. Problem number 2, to reassure the public and still instinctive fears in this interim when definitive facts for giving complete assurance are still lacking, when scientific doubts must remain, and when new unfavorable information can emerge from some laboratory at any time. To act as a bombshell on the whole... Oops, sorry. I was going to finish that sentence. Could you go back? To act as a bombshell on the whole industry, tobacco industry, if it has meanwhile tried to poo-poo the unfavorable finding to date. Next portion. The fact is, of course, that no one who has been a heavy smoker is going to benefit himself now by falling into a panic and eliminating the pleasure and comfort of cigarettes. He might just as well go on enjoying his smoke in this interim while research pursues the facts with full assurance that if any cancer-causing agent is ever really found in tobacco, the manufacturers will quickly find a way to eliminate it. Go ahead. The Frank statement is exhibit number 307. Sorry. Oh, that one? All right. So let the scientists do the worrying for us. That's their business. And meanwhile, let us go on eating and working and playing and smoking and relaxing and riding in automobiles and living a good life every day. You can count on the cigarette companies, who have obligated themselves to pour millions of dollars into cancer research, to take anything out of your cigarette that is a health hazard if our science ever really finds such hazard in the wonderful tobacco leaf. That's the last one. Go ahead and do the Frank statement, PT 307. Ron, I don't know if I moved in the last two, but that was 2061 and 1044.
Okay.
And we move in PT 307 as well.
Okay.
This is the Frank statement, the Tobacco Industry Research Committee. If you would, please just go straight to the highlighted portions, from there down to the end of that column. Distinguished authorities point out that medical research of recent years indicates many possible causes of lung cancer. There is no agreement among the authorities regarding what the cause is. There is no proof that cigarette smoking is one of those causes. Go, if you would, please, to the bottom and show who's signing off on that. The Tobacco Industry Research Committee, and it identifies its sponsors: American Tobacco Company, Brown & Williamson Tobacco Company, R.J. Reynolds Tobacco Company, among others. Go ahead to the other column, or below that. We accept an interest in people's health as a basic responsibility, paramount to every other consideration in our business. We believe the products we make are not injurious to health. We always have and always will cooperate closely with those whose task it is to safeguard the public health. That's it, right. For more than 300 years, tobacco has given solace, relaxation, and enjoyment to mankind. At one time or another during those years, critics have held it responsible for practically every disease of the human body. One by one, these charges have been abandoned for lack of evidence. We have next, Your Honor, PT 3695.
Okay.
Which is a progress report from the Tobacco Industry Research Committee meeting in 1954. Yeah, okay, you're right, 3694, I'm sorry. And, Your Honor, that is a public relations report from 1955. The previous one was 1954. And we move that in at this time.
Okay.
And the portion that we'd like to publish of the report starts with the heading, Factors Show Improved Position. Number 1. The first big scare continues on the wane. Number 2, the research program of the Tobacco Industry Research Committee has won wide acceptance in the scientific world as a sincere, valuable, and scientific effort. Do you have any more from that? No, that's okay. No, let's skip that. The next one we have, Your Honor, is 3289. That is the report on visit to USA and Canada dated April 17 to May 12 of 1958. That was the document we had some discussions about, Your Honor. Okay. We move that in at this time. Go, if you would, please, to the itinerary. Members of the jury, that page of the document we're going to show you is a calendar with a list of people these folks, Bentley, Felton, and Reed, spoke to. And where they're from. So on April 17th, they spoke to folks at the American Tobacco Company, and the folks they spoke to are identified in the right-hand column. On April 28th, they spoke to people, among other places, at the TIRC, that's the Tobacco Industry Research Committee. Go ahead. On May 5th, they spoke to additional people at the Industry Technical Committee of the TIRC, and then later spoke to Drs. Little, Hockett, on May 8th at the TIRC in New York, and then after that spoke to the Scientific Advisory Board on May 10th of that year, 1958. Later in the document, members of the jury, there is a discussion of what they found when they spoke to those people. With one exception, H.S. Green, the individuals whom we met believe that smoking causes lung cancer, if by causation we mean any chain of events which leads finally to lung cancer and which involves smoking as an indispensable link. So if you would to the next section. Carcinogenicity of smoke to animals. No possible doubt now remains that Winder's results using mouse skin painting are entirely genuine. The conclusion. Although there remains some doubt as to the proportion of the total lung cancer mortality which can be fairly attributed to smoking, scientific opinion in USA does not now seriously doubt that the statistical correlation is real and reflects a cause and effect relationship. And that's the report from British American Tobacco, which was PT 3289, Your Honor. The next document we have, Your Honor, is from the files of R.J. Reynolds from Alan Rodgman. It's PT 3709. It is the smoking and health problem, a critical and objective appraisal. Did I say it was 1962? That's the date of the document. We moved that in as well, Your Honor.
Okay.
Do you have the first paragraph on it? Can you just read it? Is this up? Are you going to get it up? I think it's going to be tough to show. There you go. Are you able to get the other pages too? Yeah. Okay. This is the document that's been admitted, Your Honor. It's PT 3709 from Dr. Rodgman, R.J. Reynolds, 1962. And can you show the first paragraph, please? Cigarette smoke contains 14 polycyclic hydrocarbons and 3 heterocyclic nitrogen compounds known to be carcinogenic to mouse skin. The hydrocarbons include benzanthracene, benzoparylene, benzopyrene, benzoepyrene, chrysene, dibenzanthracene, 1-methylpyrene, colanthrene, dibenzopyrene, dibenzoaipyrene, that was dibenzoAH-pyrene, dibenzoAl-pyrene, 2,3-dihydro-1H benzocyclopentothracene, and another one. Is that it? Are you doing that to me on purpose? Right. Can you show the part that I wanted to show? Thank you. Obviously, the amount of evidence accumulated to indict cigarette smoke as a health hazard is overwhelming. The evidence challenging such an indictment is scant. Yeah, go ahead. Members of this research department have studied in detail cigarette smoke composition. Some of the findings have been published. However, much data remain unpublished because they are concerned with carcinogenic or co-carcinogenic compounds or patentable material. This raises an interesting question about the former compounds. If a tobacco company pled not guilty or not proven to the charge that cigarette smoke or one of its constituents is an etiological factor in the causation of lung cancer or some other disease, can the company justifiably assume the position that publication of data pertaining to cigarette smoke composition or physiological properties should be withheld because such data might affect adversely the company's economic status when the company has already implied in its plea that no such etiologic effect exists? That concludes the reading of PT 3709. And the next one, Your Honor, is PT 3615. It's a strictly private confidential memorandum dated July 17, 1963, from Addison Yeaman, labeled Implications of Battelle Hippo, HIPPO, Roman 1 and 2, and the Griffith Filter. And the first portion we'd like to read, Your Honor, is, we moved that into evidence, Judge, I'm sorry.
Okay.
Go ahead, Bill. The TIRC, in my opinion, the TIRC cannot, in my opinion, provide the vehicle for such research. It was conceived as a public relations gesture, however undefiled the Scientific Advisory Board and its grants may be. It has functioned as a public relations operation. There's some more excerpts. Moreover, nicotine is addictive. We are then in the business of selling nicotine, an addictive drug effective in the release of stress mechanisms. But cigarettes, we will assume the Surgeon General's committee to say, despite the beneficent effects of nicotine, may have certain unattractive side effects. 1, they cause or predispose to lung cancer. 2, they contribute to certain cardiovascular disorders. 3, they may well be truly causative in emphysema, etc., etc. We challenge these charges, and we have assumed our obligation to determine their truth or falsity by creating the new Tobacco Research Foundation. In the meantime, we say, here is our triple, quadruple, or quintuple filter capable of removing whatever constituent of smoke is currently suspect while delivering a full flavor and, incidentally, a nice jolt of nicotine. And if we are the first to be able to make and sustain that claim, what price? Hint. We have also, Your Honor, PT 3681, which is a document from the files of Philip Morris, Tobacco and Health R&D Approach, presentation by Dr. Wakeham at a meeting held in New York on November 15th, 1961, and we move that into evidence. We have a few portions from this document. Go ahead, Greg. That's the first one. Some definitions for the cancer controversy. Carcinogen is defined as a substance which applied to the tissue, a substance which applied to the tissue of a test animal gives rise to tumor formation. In tests for carcinogens, it is assumed that tumors ultimately lead to cancerous growths and that a carcinogen so demonstrated in test animals is dangerous to man. Contains a list of a partial list of compounds in cigarette smoke also identified as carcinogens. I'm not going to try and read them, but there are a few others that we did not see previously. And then the last section we have for reading, Your Honor, of this document, it says reduction of carcinogens in smoke. To achieve this objective will require a major research effort because carcinogens are found in practically every class of compounds in smoke. This fact prohibits complete solution of the problem by eliminating one or two classes of compounds. The best we can hope for is to reduce a particularly bad class, in other words, the polynuclear hydrocarbons or phenols. 2, present technology does not permit selective filtration of particulate smoke. May I ask counsel?
Go ahead.
Your Honor, the subject matter shifts slightly. We do, as Your Honor knows, we wanted to do some of these with a live witness. We do believe he'll be here in the morning, so we can complete the rest of those with the live witness.
Okay. All right, ladies and gentlemen of the jury, thank you for your patience and attention today. We're going to adjourn with you all for today. I'll ask you to be back at 8 o'clock tomorrow so that we can get started in the morning. I will again advise you not to discuss this with anyone or amongst yourselves. You may not discuss anything that happened in court today or anything about the case with any family members or friends. You may not do any independent research. Keep in mind that you all will be deciding the case based on what is presented here in the courtroom. All right? Thank you. Please walk out with Victor. Have a great night. I'll see you tomorrow morning.
All right.
Counsels, please take a seat. Anything else we can take up now that they've all exited?
Well, maybe one thing, at least to start, Your Honor, we can discuss some scheduling issues, and I'll reference those before Ms. Denney is opening. I recall we had a hearing, maybe a kind of a status conference back in June of this year where we discussed the trial setting. Actually, we had 3 weeks. I believe the prediction was made at that point that the trial would take 2 weeks, perhaps a day or two into the 3rd week. Obviously, as we find ourselves now, we're sort of in the middle of the 2nd week. Just have done openings and have had no witness.
What are you requesting of the court?
Well, one thing I wanted to make the court aware of, and as plaintiff's counsel aware of, I haven't discussed with them yet, we have a witness who, frankly, before trial started, we anticipated would be called this week because we thought we would have the case as a defense at the end of it. The last day that they can testify before having an unavoidable conflict is next Monday, which is August 18th, I believe. So, depending on where we are, I'm not sure if the plaintiff will be done with their case at that time. But if not, we would request to be able to call that witness out of order so we can get him on the stand.
Okay. Plaintiff?
Who is it? Is it an expert or somebody else?
It's an expert. A man named Dr. Lawrence Brooks.
Well,
we would object to that, Ron. They've known about this conflict and they've kept it to themselves. They could have taken this witness's deposition by videotape and played it here in court. But they chose to say nothing. And they chose to say nothing when the court told us last week we're not going to have court on Friday or Monday. And so that made things difficult for us. And you've seen how we're having witness issues, and we live with that. And so if they don't have a witness, they've got another witness, another medical witness, who can testify to the same things as Dr. Brooks. It wasn't lung cancer, it wasn't caused by smoking. So they made a decision to say nothing and not take a video depo, and now they want to call an expert witness in the middle of our case, and we object to that.
Any response to that?
Contrary to whatever that was that Mr. Gustafson said, we didn't know about this until very recently. We also didn't know about the fact that we were going to have a 4-day all along until we came in last Monday and learned about that. We were operating under the presumption.
When did you learn about the issue with this witness?
I believe we learned, Your Honor, towards the end of week before we started trial. And whatever that week we had the motions here. That's standing here now, that's my best recollection of when we learned of the witnesses conflict. And it is a work conflict. The witness is from Los Angeles. He is, I believe he's the medical director, chief of whatever pulmonology unit he's in charge of, and he has to be back at work Tuesday the 19th for that time. This is not a problem we could have foreseen before trial started. Frankly, I think we didn't have what was probably a surprise to both sides of no court on Friday, no court yesterday. May not have been an issue. I think it may be an issue now. I think the issue is probably exacerbated now by the fact the plaintiff did not have a witness. And we emailed the plaintiff on Saturday this past weekend and said, tell us who your first witness will be so we can plan. We didn't hear anything until yesterday. And we know where Dr. Proctor is, the first witness is up in Broward County. We know where he was in his testimony on Friday and yesterday. And obviously to the court, the plaintiff was well aware that Dr. Proctor was not going to be replaced. They did not share that with us. They did not share that with the court. And I can tell you that they knew that because the person who's doing their graphics is the same company that's doing the graphics just up in Broward County. So they know exactly when the witness is on direct. He didn't finish direct examination until this morning, close to lunchtime.
All right. Mr. Beck, I would need to hear specifically what you're requesting, and given that you knew this potential issue before we started and did not raise it as a possibility to take the deposition either Friday or Monday while we were not in court.
Well, Your Honor, past that second issue, we didn't know we had no even remote belief that our witness would run into a problem based on how long the trial was represented. There wasn't even a thought in our mind that we could be in the third week of trial and not have gotten to the defense case yet. We were operating under that belief based on what the plaintiff told the court back in June. This case would take 2 weeks and perhaps a day or two of the third week. That is now not the case.
All right. Plaintiff, assuming all of your witnesses are available beginning tomorrow, how much longer do you have?
We would, I would expect that we would finish our case on Tuesday. Mr. Barnhart says Wednesday.
Well, that's going to be a problem, Your Honor, because...
Well, we're not. She just asked a question.
I'll get back to you. So, you're looking at the 19th or 20th?
Yes, Your Honor.
Okay. All right, so given the 3-week trial period, that would be 7 trial days for the plaintiff and 7 trial days for the defense. I'm counting correctly.
My understanding of the trial has to be over by, as I told the jurors last week, the trial would be over by the 22nd, which is next Friday. If the plaintiff goes until Wednesday and we need to have closing arguments on Friday, that leaves the defense 1 day to put on its case compared to multiple days for the plaintiff. I mean, that's just not, does not satisfy the process of injuries.
Is your witness available, perhaps not Monday, but sometime later in the week?
My understanding, I'll go back to him and ask, my understanding is...
Because we could fit him in later in your case.
My understanding is the issue is he was available at the end of this week, which is when we thought we would be on our case, and could make the following Monday available, but any time after that, for that week at least, he was off.
Okay, I would need to know how long after he's unavailable and the specific nature of his unavailability. If you can find that out, we'll take it up in the morning.
Yes, Your Honor.
Okay.
If I may, we still have the issue that's kind of the elephant in the room as to we get 1 day for our case under this schedule. And as Mr. Begg said, that just doesn't satisfy any kind of due process. We have witnesses too. We're entitled to time to put on our case and equal time to put on our case. And
Okay. All right. How many more witnesses does the plaintiff intend to put on?
Just counting, Jeff. Seven.
All right.
That's including fact witnesses that are very short.
All right. When we leave here today, you all are instructed to contact all of your witnesses and line up their availability. To the extent that the plaintiff's case extends until Tuesday the 19th, the defense can extend its case till the 25th or 26th if need be. All right, anything else? But if you all could tonight, both sides, I need to know all witness availability issues before we start tomorrow morning.
Your Honor.
We'll do it. Thank you, Your Honor.
Just one last thing.
Yes.
If we're going to be permitted, and I appreciate the court's indulgence to go into that next week, 2 things. One, I think that we've made clear to the jurors that we're going to end on the 22nd, so I think we need to make it clear to them that there's a possibility it goes forward. And if so, that there's not going to be blame placed on the defense for that happening because we go last. And I'm not saying blame should be placed on the plaintiff, but just that we can say that unforeseen circumstances or whatever.
I can address that in the morning.
Thank you.
Okay. Anything else? All right. We're adjourned. I'll see you all at 8.
Thank you.
Thank you, Your Honor.
All right. We're not adjourned.